such an outstanding conference here at the University of Milan, and to finally discuss with dearest colleagues and long-time multidisciplinary experts about a topic so poorly discussed, at least in the national and European scenario. Although laws have been discussed in recent decades about violence against women, this form in particular has always been almost neglected in the debate and very scarcely highlighted. Not surprising, except for the 3 states in Latin and South America, Venezuela, Mexico, and Argentina, as we will see later today, no other states adopted a specific regulation on OBGYN violence, and even sooner, very few data can be gathered at this point to even start to investigate the specifics of the perilous form of violence and to bring some pilot cases before national and supranational courts. First of all, I would like to welcome our guests for the University of Montreal and the University of Ottawa for having accepted our invitation that builds on a previous conference we had last December in Montreal, and that launched the idea of starting to cooperate together between Professor Audrey Ferron-Paraire and Professor Nardocci and myself on OBGYN violence on a comparative and cross-national perspective. Before giving the floor for their introductory remarks, I wanted to thank all of you, and then I give the floor first to our Deputy Rector, Professor Abbraccchio. She's a scientist, and we wrote together a book about women scientists in the history, and I think that we go on in next year to write together and to study this problem together. Thank you.
Absolutely. Thank you very much, Marilisa, and first of all, welcome to everybody. We are very, very proud to have here 2 colleagues from Canada, and I am also very grateful to Marilisa for involving me, as usual, in these very, very interesting interdisciplinary events. And, you know, on behalf of the University of Milan and of our rector as well, I wish you very, very fruitful works. Well, first of all, I want to acknowledge also the contribution by the Department of Italian and Supranational Public Law. We have a representative here. Also want to acknowledge the CUG, which is the Comitato Unico di Garanzia. So it's our committee devoted, you know, to acting as a guarantee organ inside the university for a variety of issues regarding, you know, equal treatment of persons and so on. And I also want to remind that the event today is also organized thanks to HumanHall, which is a new initiative headed by Marilisa herself. This is an extremely important initiative where research is put at the service of inclusivity. And this is one of the initiatives of the so-called PNRR, which comes from the NextGenerationEU funding we were mentioning a few minutes ago with the Canadian colleagues. I was explaining them what these funds from Europe are. It's very, very important to organize such intersectoral and very transversal meetings involving people from different sources and experiences, you know, not only jurists, you know, who are extremely important, of course, in the also decision taken on this critical topic, but also physicians who face this problem every day, and scientists as well. This is because gynecological violence is much more common than generally thought. And when Costanza asked me to introduce this meeting, I was surprised myself to realize that if you go back to your personal story, you realize that, you know, sooner or later you have suffered. Any of us women has suffered from this kind of violence without really realizing it is a violence. So it is defined, you know, the gynecological violence is defined as violence suffered during gynecological consultations or while giving birth. And, you know, there are several examples that I'd like to mention just to give you an idea of what it can be. Traumatic smear tests, misdiagnosed pain, carrying out painful interventions without anesthetic, non-consensus Obgyn acts, failure for patients to be followed up, inadequate support, and you know, probably is a much more common form of violence, being a victim of sexism, humiliation, and physical violence during the examination. For example, just to quote one number, we will hear much more, you know, many data I suppose will be presented today. Just in England, in the year 2020-21, more than half of all complaints received by the clinical commissioning groups in England regarding gynecological and obstetrics complaint, and were about neglecting physiological and psychological well-being of patients. And 60% of these complaints had to deal with erroneous misconductance in values and behavior, privacy, dignity, and well-being. All issues that, you know, put women in a really difficult position when they are strongly dependent on the help that they need to obtain. Moreover, gynecological violence that does not only happen to women, it can also affect intersex and transgender people. And, you know, it has taken a really a long time to be recognized. And, you know, paradoxically, we were discussing this at lunch as well, paradoxically, the first countries to raise this issue and to really pose it as a problem to be solved were Latin American countries, which, you know, is very, very indicative. We were asking whether this is due maybe to the high incidence over there, or, you know, what is, or to a special sort of sensitivity to this kind of issues. We had to wait up to 2019, which is only 5 years ago, to have, you know, this kind of violence recognized by the United Nations as a serious, I'm just quoting, serious violation of women's human rights occurring across all geographical and income level settings, so completely independent also from the income and social settings of people affected by this problem. And in Europe, the Parliament of the Council of Europe and of the European Union have only very recently adopted the resolutions and draw attention of member countries to this problem, to the point that very few European countries do already have currently a proper regulation of this kind of violence. So it's extremely important that people from different backgrounds are here today to discuss these issues towards a better understanding of the problem and towards, you know, a very clear regulation to punish this kind of behaviors and also to prevent them. So thank you very much for being here.
And Professor Abbraccchio, I'm happy for your introduction, very not formal but substantial. And now I give the floor Professor Francesca Marinelli. Professor Francesca Marinelli is in quality of a member of the Equal Opportunity Committee, our CUG, the University of Milan. Thank you, Francesca.
Thank you very much for having me. I speak in behalf of Professor Sara Barabita, who is the president of the Equal Opportunity Committee. Professor Abbraccchio and Professor D'Amico said something about this committee, which is a very important institution here at the University of Milan. Why? Because this committee has the role, and it's a mandatory role of the law, to guarantee the principle of equal opportunities and fight against any form of discriminations in the workplace, the public sector. And as Professor Abbraccchio said, when we are speaking about discrimination and violence, we said something at lunch about that. We are speaking about something that is the very heart of our lives, because it's something that is part of our background, and we don't know, perhaps also of our future, in particular in the workplace. It's an increasing phenomenon, and this is why the International Labour Organization, which is the specialized agency of the United Nations, speaking about labor, has enacted the Convention 119 in 2019, so during the COVID pandemic, just a little before, because of the fact we have to act to stand up against this form of violence and the discriminations in the workplace. Only to say that the equal opportunity committees have increased their role in facing violence in the workplace after the governing directive that has been enacted on the 29th of November in 2023, so only 4 days after the International Day for the Elimination of Violence Against Women. And this directive is very important because it says something very important for us that are part of this committee, which is that the CUG has to embrace the role of acting against, in particular, violence against women. So there is something that we have to do. It's a binding request from the law, in particular to try to disseminate material in order to raise awareness about that, and then also to train the employees, because there is something that we have to face, the fact that not always we recognize what is violence in the workplace. We discussed that during our lunch, because it's very connected to the values of the society. And so it means that it depends on the time, on the position, on the hierarchy. So, of course, when we're speaking about that, we're speaking about something that we need to face. The last thing that I would like to remember is that our government created a free telephone number, 1522, which is a free number in order to try to ask help for advice if you need it. And I think that this is something that we should spread, because of course it's something that can contribute to fight violence even in the workplace. Thank you very much.
Thank you, Francesca and Professor Marinelli. Thank you for your very interesting consideration. And now I give the floor to Professor Antonia Baraggia. She spoke for our department, the Department of Italian and Supranational Public Law. I give the floor.
Thank you very much, Professor D'Amico. Yes, I'm here on behalf of our director, Professor Malpitano, to welcome you to this very important conference organized by our colleagues, Professor Marilisa D'Amico and Professor Sant'Antonio. I'm a scholar in comparative law, and so as a scholar in comparative law, I'm well aware of the responsibility we have to address this critical issue that affects the lives of so many women and families also around the world. And Professor D'Amico is the leading expert in the field of women's rights, gender equality, and today's conference stems from her commitment to really advance women's rights in all their different dimensions. So even in light of a very specific phenomenon like the obstetric violence, which is literally understudied, especially in the legal field, also in comparative perspective. And so obstetric violence is a term that encompasses the various forms of disrespect, abuse, neglect that women may experience during childbirth, but not only. Obstetric violence is related to more in general the sexual and reproductive sphere, so gynecological examination, abortion, breastfeeding advice, contraceptive prescription, and assisted reproduction. So this is a form of violence that remains a deeply entrenched problem in many healthcare systems, and sometimes even in hidden problems in our healthcare system. And it is a violation of human rights, a breach of trust, and the stark contradiction of the ethical foundation upon which the medical profession stands. And from a comparative perspective, Professor Abbraccchio has already mentioned, it is a fascinating example of the leadership role that countries in the global south can play in advancing the protection of rights. The concept of obstetric violence was born in Latin American countries late in the 90s. Largely thanks to the activism of associations working for humanized childbirth and reproductive rights. And it raised civil society awareness of the need to establish a discipline to deal with the ill treatment by health professionals. And so this legislation was introduced in countries such as Venezuela, Argentina, Mexico, and Uruguay. And this issue has now become internationally recognized and has begun to attract the attention also to the European Union and institution at European level. So thank you so much to my colleagues and to the prominent speakers that have accepted to share their expertise on this fascinating topic. And we are here today to shed light on the shadows where obstetric violence hides and to pave the way for a deeper understanding of the policies that can protect the rights and the well-being of women around the world. So thank you very much and welcome again.
Okay, so thanks so much, even on my behalf, to Professor D'Amico, who is my mentor here since 2009, actually, so it's a long time, and for supporting me in, the organization of these initiatives, and also that started, yes, as she said, last December, and when we started focusing on obstetric and object violence, but of course we are working on women's human rights since many years now together, and we're all as working group, because it's not only me, but it's we are a very large group of people. Some of those are here, and thanks so much all of the group for helping us out and working with us. I'm also honored to host both of you from Canada, because the idea of collaborating actually started out because we felt that there was like a gap to fill, common criticisms, common challenges, despite the fact that, yes, Canada, at least in here, has a very good reputation, and they keep on telling us, no, it's not true. So we'll see how is the situation in Canada. truly. The interesting part from our perspective of this very first session is not merely due to the fact that we will focus on the Canadian situation, but because we will do it from both sides of the legal scenario. So we will have someone talking about the civil limb, the civil dimension of object violence, and someone who will shed light on the criminal law implications of this phenomenon. So I will start by giving the floor to Audrey Perron-Carayou. Okay, so the title of our presentation is Civil and Disciplinary Liability for Object Violence in Quebec. Many miles to go. She's from the Faculté de Droit, University of Ottawa, and I give the floor to her. Thank you so much on behalf of all of us for honor us with your presence. There can use it, please. Okay. I don't.
I don't
Okay.
want to
To
hold the mic.
Okay, right. I see.
Thank you.
Okay, okay.
Thank you so much. Thank you, everyone, for welcoming us so well in Milan. I was pretty impressed to see all these women professors and physicians who are here today. It's warming. Yeah. So I had on the program I had two titles. So I'm gonna go with a presentation on a broader presentation on where are we in Canada with obstetrical and gynecological violence, and then I will focus more on civil liability. That's working.
Yes.
Super. So Professor Abbraccchio already described very well what is, I will say OGV to make it shorter and to not mix my tongue with gynecological word every time I speak. So OGV. So what is it exactly? Well, you had a very good description earlier, but I just want to put an emphasis on the very gender nature of this kind of violence. To our knowledge, at least no men ever give birth to a child. So although there is intersex and transphobia and trans identity issues with OBG violence, there is no men who have done this, experienced it. So that's the first thing. The other thing is that it's a systemic violence. So it's not merely one person being violent with another one. It's how we are socially, culturally, historically, how the disciplines are working, how the society is organized, how the health systems are built that may lead to this violence, and not just one person being violent with another one. And the last thing I want to put emphasis on is it violence though? Is using the word violence too strong? Could we find another word? And this is a critique that comes very often from the health fields professionals, which are saying, well, we are not violent. I mean, we care for our patients and we want to do what's best for them and we want to be helpful, and that is 99.999% of the time true. The only thing is that when you take into consideration the systemic problems that lead to OG violence, and when you look at the epistemic injustice that is behind this, epistemic injustice in the way that women usually don't even realize that they are experiencing this kind of violence until you name it. And as one professor was saying, I can't remember, but when you start to think about it and when you talk with the women around you, you usually find out that everybody's saying, oh yes, I did suffer this kind of treatment when I was having a child, or when I first have my first gynecological appointment at 14 and I didn't know what was going on. So it's really more of a system, and it's the epistemic injustice behind it that makes the word violence the more appropriate. And there tends to be a consensus in the literature, at least in the social science literature, around the use of this word.
So I was going to say a few words about how the Haut Conseil à l'égalité in France, so the High Council for Gender Equality in France, decided to give example because it's quite, you see the continuum, you see the gradation between what you could call soft violence or normalized violence, or the things that we all live through and say like, well, that's life, that's what happened. So it was going from no consideration for discomfort, which is happening to everyone. Like, did we offer you something to cover you? Did someone open the door while you were exposed? So all this kind of little discomfort that you experience and that there's no consideration for it, up to sexual violence, which is really when women are saying, I felt raped during an exam, which was probably not done with the intention of a rape, but was felt by the person who lived it like a rape. And I would add with the sexual violence, the forced sterilization, which we are going to talk more about with Dominique's presentation. But that is an issue in Canada. As you may know, we have indigenous population, and we are starting to have very disturbing data on how they are sterilized without even them consenting or even knowing about it. And in between all of this, you have the sexist judgments. So having a comment that, well, you may not get pregnant because of your weight, or that you may get diseases because of your sexual habits, or that you may have experienced something because of the way that you're dressed, or because the way that you your lifestyle. And you have the acts that are done without informed consent, so with no informed consent at all, or just well, we did have consent, but you didn't really knew what you were consenting to, so that was not informed at all. And the acts that are done without medical justification. And that's tricky because when you look at literature, and the scientific literature, often we don't agree on what is medically justified. So something that may be presented as being medically justified, we even see it between hospitals in Montreal. What can be presented in one hospital as being medically justified is going to be presented as an option that is not really medically justified in another one. So the range of what you can feel as being violent, depending on the experience you had in a particular clinic or hospital versus the friend you are talking to who had a childbirth in another hospital, is going to be varying. And that's another core characteristic of this kind of violence, but as any form of violence, I would say, it depends. It is a subjective experience. And I was doing research on domestic violence. And in the 80s in Canada, we had all this debate about, is domestic violence a real violence? Because, you know, it depends on every woman. So how can you say that it's violence if it depends on every woman? And we are seeing the same debate now with OGB. Is it really violence if it depends on every woman? My answer, in short, is yes. So how common is it? That's a good question, which we don't have many answers to, because we are starting, it was pointed out earlier, we are starting everywhere on the planet to look more deeply at this issue. So we don't have a lot of data, but some more robust data that has been done, some in the United States, and some of the other examples I'm giving is Netherlands. So in 2019, there was a study published in the United States, which is called the Giving Voice to Mothers study. It was a survey done on over 2,000 women. And from what they saw in the data, that 1 in 6 women experienced one or more type of mistreatment during childbirth, and up to near 1 in 3 women had this experience when they were giving birth in a hospital, compared to midwife clinics or at home. The other important survey we have was published recently in 2022 from the Netherlands. That was, I don't want to mix up the numbers, but 12,239 participants. So that's quite a big sample. And from the data they get, there was lack of choices in almost 40% of the treatments that were done, and 36.3% of women experienced at least one situation of disrespect or abuse that they did considered as upsetting, so that they did feel upset about it. In Canada, we are actually doing two big research projects to get a better view at what is the incidence, what is the prevalence of OGV. There is the Respect project that is all across Canada, which is financed by the Canadian, the Canadian Institute of Health Research. It's the same survey that was done with the Giving Voice to Mothers in the United States. And the survey is closed, so we should get the results very soon. I was hoping that they would publish them before I came here, but they did not. That would have been good. And the other project is the Parole project, which is more specific to the province of Quebec. But again, it's trying to figure out exactly the same thing. And how, when we say that it's common, how common is it actually? And can we have a survey with a sufficient number of participants to have a good grasp at this? And in Quebec too, the survey is now closed, and they are actually going through the data, so we should have it.
Right.
Anytime soon.
Second round conference.
Yes, but the fact that we don't know, we don't have specific data still on how often it is, doesn't mean that we don't have a sense of the fact that it must be more common than we first thought it is. And just looking at the newspaper in Quebec is giving us a good example. I will not translate everything, but it's just to give you a range of all the paper that's been done since 2019 on the subject. And it's all over, from obstetrical violence, so women that experience violence during childbirth, through forced sterilization on Indigenous population, and to gynecological violence, which was mostly in the news. It was mostly surrounded the issue of having an IUD. Yes.
Yeah.
The IUD inserted and taken out. Yeah, there was a bit of translation.
It's fine.
So that's something we see more and more often in the news. Now, what is the law? What does law have to do with that? How can we use it? So in Quebec, we decided to look at law in a broad perspective, and we had two projects that were submitted for funding and that received this funding. One with the CIHR, which I think, and the other one with the SSHRC. The first project is really looking at law as a prevention tool. So the idea was saying, well, upstream, can we use law to prevent the occurrence of OGV? We are centering this project around, well, do women know their rights? Are they able to advocate for them? So are they able to ask for things and to say no when something is happening to them? How is it understood by the healthcare professionals? So do healthcare professionals know the women's right? And how do they feel when someone is saying, I don't have enough information to give you an informed consent. Could you please tell me more? Is it perceived as a good thing or as something threatening their professional position? And the other thing we want to look at is, what do women do when things turn wrong? And on the other downstream of law, we wanted to look at justice. So is law a tool for the victim? So if you do experience OGV, what can you do? So what are the remedies that are available? Are they effective? So it's one thing to say, well, sue. If you're not happy with the care you received and you think you experience violence, you just have to sue your physician. Right, I could, but is it going to be effective actually in real life? We also believe that they can both, the prevention, the justice for the victim, they can both influence each other, meaning that the more people know about their rights and the professionals know about the women's rights, the more they are committed to defending them, the more remedies will be effective to grant justice for the victims. And therefore, if we have remedies, they will reinforce the role of law as a protection tool. So we really see them as being both influencing. So for the rest of my presentation is going to focus really on the access to justice. The broad project is going to look at 4 types of remedies, different remedies. So civil liability, disciplinary liability, so it's all that is pertaining to professional codes and the sanction boards that ensure that professionals are respecting their obligations, the criminal justice systems, and the healthcare complaint system, which is something that is in the law. That is every hospital, every establishment, healthcare establishment has one commissioner that is receiving all the complaints and that is treating them. So for now, we are broadly looking to evaluate each remedy. What does it include as their own characteristic, their own conditions of application? And regarding OGV, we are going to see, do we have any case law in each of these remedies? What is the case law and what does it tell us about how it is received? And then we're going to explore what are the barriers and the facilitators for the victims when they think about accessing one of these remedies, or the women that already did. So we're going to have interviews with women to be able to say, well, the conditions of application are but in real life, no one is able to get to this. Which brings me to the civil liability. So today we're going to focus on civil liability and then the criminal justice. And the title was saying disciplinary, but let's face it, I cannot do that in 30 minutes. So it's going to be just civil liability. So the first thing is that there are different rights that are involved in Quebec in OGV. I will not get specifically through them, but just there is first the Quebec Charter of Human Rights and Freedoms, and there is the right to freedom, the right to the security of the person, the right to the integrity of the body, the right to dignity, the right to privacy. They are all fundamental rights that can be threatened by OGV. The Quebec Charter is not part of the Constitution, but has what we call a quasi-constitutional status, which means that we can change it by, like we would change any other law, but when the courts are analyzing the law, they have to, it has a preponderance over other rights. In the civil code, we have the right to integrity and the right to privacy. And in the right to integrity, we have all that concerns consent to care. And that is the part where I will talk more about. And the other law that is really important is the Act Respecting Health Services and Social Services, which has consent, privacy, the right to be informed, the right to be a part of the care plan, the right to receive scientifically, humanly, and socially appropriate care. And I want to focus on the informed consent care because it's in all the literature we have on OGV is really something that is common. You saw the results from the survey in Netherlands. The most common form of OGV is having been submitted to one kind of care or another without consenting or without giving the informed consent. So how does informed consent works in Quebec? Well, first, there is an obligation of information for the professional. which has to contain sufficient information to be able to be informed. The nature and the purpose of the care that is presented. What do you suffer from and what do we need to do to be able to fix it? What are the risks and the benefits of the treatment that is proposed? What are the therapeutic alternatives? What is the risk of doing nothing? That's interesting because in the literature and in the case law, we often see that as being something that is missed. Well, you didn't tell the patient what was going to happen if you didn't do anything. So, and that's part of the law. There is also an obligation to answer questions, all the questions. So the physician or the nurse can never say, well, your question is too specific or it would be too complicated to explain to you. So just, I will not answer it. There's an obligation to answer every question. And there's an obligation to ensure understanding, which is, as you might figure out, something that is really missing most of the time. The thing is, with the right to informed consent, there's also the right to refuse, and the right to refuse, even if that leads to death. Obviously, that is for people that are capable of making a decision, but as long as you are legally capable of making a decision, that you did receive the information, even if saying no to a care is going to lead to your death, you can do it. So a few words on civil liability. How does it work in Quebec? So you have to, that's not clear for some people, but in Canada, we have two different legal systems. So in Quebec, for private law, we have civil law, as in France, as in Italy, as if we had our first civil code was the Napoleonic Code. So we are really civilists. For private law matters, but for public law matters, we are common lawyers because we were, as you may or may not know, we were conquered by the English in England back in the days, and so we have this dual system where when we had our constitution done, we went on with the public law as common law, but to be sure that the French, who were still in the province of Quebec, would not rebel against the system, they gave them their civil law system to buy peace, actually. So that explains why we have still this dual system. And all that is criminal is for federal government and is from common law. Back to civil liability now, we mostly have 4 medical duties: duty to diagnose, duty to treat, the duty to follow up, and the duty to have consent. And in the following case that I will present, I'm going to divide them between the technical duties, which are diagnosis, treatment, follow-up, and the consent duty, just to make sure that the difference is understood. The obligation is an obligation of means. So we normally say that what a reasonable, competent, diligent physician would have made in the same situation. That's the threshold to distinguish between what was a normal behavior and normal care and something that led to a fault. We have 3 components to civil liability: fault, the injuries, and causation. A few words about those components. So the fault, as I say, the threshold is going to be a reasonable person. So what another physician with the same experience and the same expertise in the same situation would reasonably have done. If you fall out of the reasonable range, then there is fault. If you're still in the reasonable range, then there is no fault. That means that if there is 2 schools of one school, medical school, saying, well, we do this, and the other say, well, no, we do this, and there is a strong opposition, but 2 strong medical schools for one subject, the judge will not If you respected one or the other, you're going to be okay. If you did not follow any agreed upon way of doing things, then you're going to fall outside of what is reasonable, and there's going to be loss. The other thing is the causation. When you have a technical fault, the causation is going to be mostly scientific. Although we don't get to the point of science, which would be like 100% sure that this led to this, it's a civil causation. So it's 50% plus one. Was it more probable that this caused this than not? But when it's technical, you're often going to have people fighting over scientific expertise. When you have consent, breach of duty for consent, then the question is going to be if the patient was given the opportunity to consent or was given the information necessary to consent, would the patient have consented? If you answer yes to this question, all causation falls. So there is no liability because you don't have causation. If you answer no, the woman would have said, I don't want this section, I don't want the forceps used, or I don't want this test, then your causation is proved and you can go to what are the injuries. We have three types of injuries in civil law. We have the bodily injury, which refers to the damages done to the person's physical integrity. We have the material injury, referring to the damages to a person's property, and the moral injury that refers to the damage to the person's extra patrimonial rights. So you can think about dignity, reputation, privacy, and in terms of medical liability, it's always bodily injury that is at stake, and sometimes a bit of moral injury, and I will talk more about that in a few slides. So for the research project, the first thing we had to do is, after we've looked at all these components, was do we have case law that are regarding OGV? So first thing we did was looking at the words. Do we have obstetric violence, obstetrical violence, OBGYN violence, gynecological violence? Did we have any of those words coming up in the database to give us case law? And guess what? No, we don't. So the next steps we had to do was to look more broadly at medical liability and then go by subspecialties up to any care that was pertaining to obstetrical or gynecological, and see what are the details of the facts, what happened, and have our own analysis and say, well, this could be judged as OGV. So we did the systematic review from 2010 to up to May 2023 with keywords very, very broad. We had a lot of cases, and then we targeted to have OGV more specifically. So we had a total of 16 cases. We had a few that were, 8 decisions that were from the small claims division, which is a division of the Court of Quebec, and the parties represent themselves. So we decided to discard those cases because we definitely had not enough details to be able to judge. So we have 15 decisions from the Superior Court and 1 decision from the Court of Quebec with the Civil Division, which is giving us more material to work with. And then we did a thematic analysis using NVivo, which is something used more in social sciences, but we decided to go through with a social science approach to see what's the vocabulary that's used, how does the judge, the court describe what happened to the women, what words are used, how do experts describe the care that should have been done. So we really went into social science approach. So on the total of the 16 cases, we had 17 cases where the liability was found, and only 3 that were regarding informed consent. So 4 were technical. So we took a closer look at how do we prove that there was a breach of duty in the consent, informed consent. You stopped me when, yes.
That was
okay.
like 5 minutes.
5 minutes each, okay, that's good. So proving a fault, how do you do that? And we were surprised to see how the experts representing the physicians were describing the consent process. So in La Langue Contestée, and all of these are from the law cases, but I translated them because they are in French. So the expert in defense points out that the patient's full participation in consenting to the VBAC, which is a vaginal birth after a C-section, is a theoretical notion. Just as it is a theoretical that the patient can withdraw or consent to a VBAC at any time, because, you know, the baby has to get out. The patient cannot be told every 2 minutes, are you still sure you want a VBAC? So that was, from this expert perspective, that was how consent should be done, which is theoretical. And by the way, you cannot really consent. So anyway, just push the baby. I'm paraphrasing, but that was what was presented. Fortunately, in this case, with the information that was given by the other expert, the judge stated, well, in La Langue, in Mrs. La Langue case, she was not given enough information to do a VBAC. She was told that she could have a uterus rupture, but she was not told what does that mean. What is a uterine rupture, and what does it do to the fetus, which is mainly that the fetus stops having oxygen. So the baby was born alive, but with severe handicaps. So the judge did found the doctor, the physician, liable in this case. In another case, Mrs. G, we don't hold her name, Mrs. G, she had had a labor that was excruciating. She had been suffered. She was in sufferance for more than 12 hours due to an hyperstimulation. So she was receiving too much oxytocin to go with the contractions. When the time came to push the baby, she was exhausted. She was not able to push, but the physicians constantly tell her, you don't want to push, you refuse to push. I've never seen a mother refusing to push her own baby. So that was the vocabulary that was used toward her. Finally, the baby was more and more in distress. So the physician just came in and used forceps without having consent and without explaining why forceps versus C-section. And the women had been asking during the labor at least 3 different times, why don't I have a C-section? I can't anymore. Just take the baby out, just do a C-section. And she never got any answer to these questions. So Dr. Mas, in this case that was representing the defense, he said, Dr. Mas doesn't present the treatment options. He doesn't explain the risk of forceps, the different types of forceps, medium, low, and at the vulva. At the time, there were medium and at the vulva that were still practiced. Or the fact that the higher the station, the higher the risk associated with forceps. Patients are not receptive at this point, and generally they just say, do the best you can. People trust the doctor, so the doctor just does what he thinks. Again, in this situation, the judge didn't go with the expert in defense, and he said the women had asked for a C-section. That was her birth plan. If she had known about the risk of the forceps, if she was given the opportunity to give consent, she would definitely not have. And so liability was found there. So when we look at how fault is analyzed by the judges, it's interesting because we see that even if the experts in defense present it as something that is normal, you do and you don't ask, judges don't buy that. But in those two cases, the proof of causation was very strong. The women were still the start asking for C-sections. That was the birth plan, and so there were no issue with causation. When we look at how the consequences are looked at, then it's a bit different, because in most cases, we really see in the history that there was, yes, in bodily injury, but there was also moral injury. But for some reason that we don't still know, because we didn't ask judges, they just tossed the moral damage away. Just one example of this, and I'm out of time, but Mrs. G, which is the woman I just talked to you about, was having a very, very, very bad childbirth experience with people, with the healthcare staff diminishing her sufferance. And the judge just said, well, despite of all of this, there were no integrity or dignity moral injury to her. And so the question that we've been asking in the project, and that we look forward to speaking with judges and lawyers, is what does it take then? Where do you have to go to consider that there was damage to the dignity of the woman, damage to her integrity, outside of just what is corporally, bodily due to you? And so that's going to be our next steps. I don't have time to talk about this one, but the next steps is going to be interviewing stakeholders from the justice system. So lawyers that do represent physicians, lawyers that do represent patients, and judges, to ask them, how do you manage all of these different problems surrounding OG? Thank you.
Thank you so much, Audrey, because you provide us a very detailed and rich insight on the, not only like the Canadian experience, but also on the forms of object violence, and on the ways in which we might actually find a way towards the civil liability. And despite the very poor case law, which is something that is common globally, these cases were actually very interesting, actually having an idea about the proof of causation. And I was also very struck by the reference to the theoretical consent, which is a very interesting and challenging issue. We have no much time to delve into this, but this is very interesting, because it seems like an implicit form of consent, something like you is taken for granted. It's like you have control over another person, you are taking care of another person, and so the consent is like theoretical, because you're assumed as a physician to be taking care of your patient, so you think you're doing the best for the patient. Okay. So let me know, Dominique, when you're, I mean, we have, I know you're ready, but it's, the presentation, yeah, you're ready, sorry. Okay, so now we move to the critical side. I will let you have the mic, because you as well don't want to hold the mic. No, okay. So I give the floor to Dominique Bernier. Her presentation title is The Criminalization of Obstetrical Violence in Canadian Law, a Possible Solution, a solution aimed for Université du Québec de Montréal. You have the floor, and thanks so much for being here with us.
So thank you. Good afternoon, everyone. I'm very happy to be here. As you heard through our accent, we are from the French part of Canada, just to clarify that. First and foremost, I rarely believe that the criminal system is a solution. I'm very critical of the coercive state of control. I have to say that because it's not because I'm a 10-year criminal law professor that I think that criminal law is a solution. And just to be, I need to start with that. Punishment also serve to discriminate. So it's very important for me to say that. I'm a mother of 3. I've given birth 3 times. It's very difficult to distance yourself from a subject like this. I don't want to diminish anyone's experience, and I don't want to send anyone to jail. Just to be sure with the physician in the room, we had a beautiful lunch, and I don't want to send you to jail, okay? But I think it's very important to think about responsibility and that understand that responsibility is a complex legal concept. It can be in the civil law system, it can be used in the criminal law system. Actually, I think we should think about responsibility about a law concept more than a field of law concept. So today I just want to think about the worst, because I'm a criminal law professor, so I always think about the worst. But I think that thinking about the worst is a way to understand the continuum of what is possible and what is not. So the last introduction mention that I want to do is this presentation is an exploration, is a working hypothesis, but as Audrey said earlier, we don't have much about OGV. We have very little to work with. So my presentation is just we start to think about it, and we are talking about it very often, trying to say, so is criminal law a part of it or not? So I'm trying to answer that question a little bit today. Just a quick word, Audrey told you earlier, like criminal law is a common law system, is a part of the common law system in Canada. So it's a public law. The states lays the charges, no interaction. There's no interaction between private law and criminal law. So I know it's different from some countries in Europe, but it's a very separate field of law that is managed all in its own system. And it's a federal jurisdiction, sorry. So it's the same criminal code across Canada. Yeah, I thought you had a question.
Yeah, no. So she said if private law means like civil law.
Yeah, civil law, private law, civil law, sorry. The private law is the term in our constitution. Okay. So civil law. So all the relation between private parties. So the first question that we have to ask to understand if criminal law can be used in OGV is what charge could it be? What charges could lay from a situation that is OGV? So in Canada, there's 2 types of offenses that we can look through. The first is offense against physical integrity. Oops, sorry, I changed it here. Okay. So the first one is assault and battery, and assault and battery is a very generic offense, and it's use force without consent. As you can see, it's very, very broad, use force without consent, and it needs a subjective intention. So you have to have an intention of the use of the force to have an assault and battery. And you also have sexual assault. Sexual assault is the use of force without consent in sexual nature. And you also need, in that context, a subjective intention. The subjective intention is very, very broad. And I will just take a minute to talk about that. A word about sexual assault in Canada. In the 80s, we had a major change in our criminal code, a major reform for sexual offenses. Following numerous complaints from feminist groups and a specific reform commission on the subject, the choice was made to create the broadest possible offense. Rape offenses were abolished. So there is no rape in Canada. There's no rape offense in Canada. We have a very, very broad offense, which is sexual assault. One of the main reasons that it was abolished, that was a rape needed penetration. So we abolish rape to have like the broadest offense possible. So it's been a while. It's for 40 years, we don't have rape. We only have sexual assault as an offense. And it was done to recognize the consensual autonomy of women and to address the myth that persists around sexual violence. The sexual nature of the contact is widely interpreted. So if you use force against someone in a context that is sexual or genital or the breast for women, it's a sexual assault. It's not assault and battery, it's sexual assault. So very quickly it becomes sexual assault. And sometimes like people are shocked by that because sexual assault is something that comes with we are thinking of a rapist, and we have like something very strong in our mind about that. But when we look in the law, the sexual assault is very large, and actually no OGV would be sexual assault if there is an offense that is there are charges that are laid around it. So it would be sexual assault. I know it can be a little bit shocking, but it's how the law is written right now. Just to understand, there were a case that about sexual, what is the nature of the sexual contact that is needed, and it was a father who used discipline, and the discipline was done around like the genitals of the kid, and it was considered sexual assault because it was in the sexual nature. The contact was in the sexual nature, so it was. You don't need an intention of sexualization, just the sexual contact. Of course, sexual assault is all about consent, and what is consent in Canada? The consent has to be real, free, informed, not necessarily verbal, but externalized. Doing nothing does not imply consent. Subjective to victim, inalienable, related to the sexual the sexual act, continuous, and can be revoked. So that's interesting because we had a case earlier about that. So can we revoke consent? In criminal law, yes, we can revoke consent all the time at every moment of the sexual act. And the person must be conscious to consent. And that's very interesting because it was added in the criminal code in 2020, 4 years ago. So before that, there was debate in front of the court about the necessity to be conscious to consent. That's interesting. So we can change. Other charges could be the offense of negligence. So criminal negligence is a conduct which constitutes a marked departure from the norm expected of a reasonably prudent person. So you can do or not or omit to do something, and it's could be an offense of negligence. And manslaughter, it's the same criterion, but that causes death. To be charged, there must be a police investigation and the exercise of a prosecutorial discretion. And in medical cases, it's very rarely used. And we talk with prosecutors, and I know that you are talking also to police services, and they are rarely agreed to prosecute in those kind of cases. It's very, very different from civil law. It's something that we don't see much, very exceptional. So we look through case law from all Canada, so coast to coast to coast, yeah, 3 oceans. So where's the third one? The North. And we have a problem with Russian with it, but it's another subject. We look at the case law, and there's very few case law about in the medical situation, medical negligence. There's absolutely no OGV, and I think one of the Audrey students, she did a very, very good research, and we don't have much about it. But what I can say about what we have seen in the case law is, first, there's difficulty in understanding the medical context when analyzing offenses, particularly in the case of negligence. Of course, what's the reasonable physician would do? It's the question. Credibility issues are remaining for victims, and myth and stereotypes are still very strong when we look at the case law when the victim is a woman. Consent remains the same legal concept, but must take into account certain elements related to the care context. And the research that we have done, the majority of the cases are negligence cases, of course. For sexual assault, leaving aside cases of repeated and systematic aggression by doctors who take advantage of their victims' vulnerability, there's few, but it's not cases that are interesting for us because it's very another type of criminality. It's not related to the care, it's more related to the power relation. And so for those cases, it's more easy to find cases and doctors that were guilty, of course, but it's kind of for me, it's something different. What about the other cases that are thought to be in the gray areas? The central question in these cases was the touch or the maneuver justified on the medical plan. So it's often breast examination that are in the case. So is the breast examination justified on the medical plan? Is it okay to do a breast examination at that moment or for that type of care or for that type of diagnosis? It's mainly what we have seen in the cases. And of course, the other question is, did the victim consent? Did the consent was a good consent? And what did the victim agree to? And again, mainly it's in the breast examination that we see that they didn't really consent that because they were not, the exam was not explained, it was just done. So it's where we have seen more cases. Quickly, I have like 3 cases that shown well what is the law around the criminalization of some medical procedure. And just a quick question: whose are against Litchfield? You can say hi to King Charles. We are still in its complicated. That's right. So a case that's such, just you can look at the quotes, but however, in determining whether a complaint actually consents to what occurred, the court must also be careful not to discount the testimony of a patient who complains of a sexual assault, and not to underestimate the vulnerable situation in which a patient who is being treated by a doctor often finds herself. So we have to look through consent. In this other case, you have like the details about what the consent should be about, that there was no medical purpose for the genital examination, that even if there was a medical purpose for an initial examination, the examination happened with unwarranted frequency, and that the examination was performed in improper circumstances, and in that case, Dr. Marshall using improper method. And the last case, the last sentence is interesting. A patient can only provide consent to a bona fide medical examination conducted for a legitimate medical purpose. So we have to look to what the patient has consent to be sure that it's not sexual assault. So now about OGV, is it a solution to aim for? A criminal law is a social reaction to crime. So we want to punish. Is it a solution to aim for? I don't think it's a solution to aim for. I think we must retain its exceptionality. So maybe sometimes we have some situation where things are going too far. And when it goes too far, maybe that criminalization could be a solution. But I repeat, it must retain its exceptionality. But we must understand consent in a feminist and non-paternalistic perspective, just to be sure that we all agree on how consent would be understood. So yes, we have to keep that for exception, but we still have to understand consent in a feminist way. Prevention and training are the solution I prefer to rely on for now, and that's what we are working on this project, more about prevention and how prevention can bring justice to victims. But criminal law is not the only way to get justice. To finish, are there contexts in which deterrence would be necessary and intersectional views is necessary here? Because even though we have good reputation about human rights in Canada, we have to take that with some consideration before saying that too quickly. Don't you think so? But there are situations that I think we need to think about some form of punishment, of some form of deterrence, like forced sterilization of indigenous women. So forced sterilization is associated with colonialism and discrimination experienced by indigenous women. Several situations are documented across Canada, sometimes systemic forced sterilization in some communities up north. And also we have a lot of situations where because indigenous communities have more babies per mother than the rest of the population. And after a couple of children, there's a lot of cases of sterilization that were performed during a C-section without the consent of indigenous women that were documented. And that is not something that is very old. We have situations like that in the 70s, in the 80s. And some indigenous women claim that they had treatment like that in the past decade. So for me, it's something that is very, very important to think about when we think about systemic violence against women. And maybe some deterrence would be necessary in cases that are systemic and based on the discrimination against a group of women that is not treated the same way in Canada. And there's two governmental reports about it that are talking about cultural genocide against indigenous women in Canada. So it's a very complex topic, but we are starting to understand what forced sterilization did on those communities, and I think it's really to think about when you think about OGV. And I have two other contexts in which I think deterrence would be necessary to think about. Black women whose pain is neglected. So some studies shows in the United States that you have 2.4 more chances of complications during childbirth if you are a Black woman. And one of the reasons for that is because we don't take their pain seriously. And there's a lot of literature about it. It's not something that I came up with this afternoon. The report that I put in my PowerPoint is very interesting. It was done by the health system in New York. And I think that even in Canada, we are thinking that we don't discriminate Black people. It's not true. And I think that we need to think about the systemic discrimination also through the health system, and to think about those studies and those chances of complication that are higher for Black women, also in Quebec and in Canada and everywhere. And lastly, I think we have to have in mind women prisoners. And women prisoners for me is it's the frontier of our human rights engagement. It's where we all fail. And women prisoners receiving gynecological or obstetrical care in prison it's something that is very, very disturbing. They are being encouraged to have abortion. Please know that I'm very pro-choice, but being pro-choice is also being to have the choice to also go through a pregnancy. And with women prisoners, it's not what is happening when they are under 12 weeks of pregnancy. They are kind of encouraged to have abortion. And the main argument is that you will not have the custody of your baby because you are in prison. So that's very important to think about. And I've heard terrible stories about OGV in handcuffs. So the care are done with handcuffs and all those things, all those kind of scenarios that you can think for women prisoners. And I know that it's a group of people that we don't have a lot of empathy for, but it's why I think it's the limit of our human rights engagement when we think about those women. So is it another context where deterrence would be necessary when we have OGV? Maybe. I think we need to think about it when we think about that. We need to think about the women that are not the women that we see in movies that are going to give birth happily to kids after a gender reveal party. It's not real life because there's a lot of women that are discriminated, and I think it's those women that we need to think about.
So now I will give the floor to Professor D'Amico, who is Professor of Constitutional Law here at the University of Milan, Vice-Rector for Transparency, Legality, and Equality of Rights. Yes, again, here at the University of Milan. No presentation on that time. Okay. So her presentation title is Obstetric Violence in the Italian Context. And I will give the floor to Carter. Thanking her so much again.
Thank you. Thank you, Costanza. Thank you for your very interesting presentation. And we have a book from this conference, so we hope to read and also to have the possibility that your ideas and your perspective could circulate also in our Italian context. Professor Cettin asked me to speak to talk after my presentation. We change a little
Sure.
Okay, it's possible. Thank you. Thank you very much because and now I try to resume my presentation that is very long, so I hope to be able to resume in. And because in reality I had a temptation to change the order of my presentation because there are many things that you told, many things, general things are much better than now I try to tell. And your perspective from the point of view of intersectionality, of feminist point of view is very interesting, and I hope to have the possibility, not today because I have to go after my presentation, but in the future to discuss and also later after the conference. Thank you. Now I try to, I start with some general consideration. And in general, Obgyn and obstetric violence was originally understood as a form of violence occurring when pregnant women are treated as patients incapable to exercise their rights to self-determination, emotionally unreliable, underserving in information and involvement in choices on childbirth and labor. Labor together with pregnancy will no longer represent a natural process, but rather a pathology in need of surveillance, hospitalization, and control over women and their bodies. This is the first point of view. And the phenomenon can manifest through various routine practices implemented in healthcare institutions, such as compelling the women to remain supine during childbirth and prohibiting the partner access, Obstetric violence continues to face with derisory comments, misogynistic attitudes, insults, and other expression of contempt, even with explicit references to sexual activity and or mother inability to manage the delivery, to give birth and bear the pain. It occurs during childbirth of the public health system, the hierarchical conflict between the relevant specialist, defensive medicine, the abuse of medicalization, the cultural prejudice about the pregnant women's inability to make decisions. And this is our point, our general and very abstract point of view, because I think that in Italy and we invited Professor Cettin and the medical perspective of an important institute in Milan of our university, and this is part of our university, because we think that it's very important to listen to the point of view of medicine, because our medicine is going on, so it's not the same situation, for example, that I lived many years ago when I had children. And so we can go on. Therefore, formulating classification hypotheses, it can be asserted that obstetric violence manifests in verbal abuse, physical violence, and the violation of consent of the abuse of authority by medical personnel. However, in the absence of the clear-cut definition of obstetric violence, it is possible to contemplate additional nuance beyond what has already been discussed, exploring various manifestations of this form of violence against women. Examining, for instance, the origin of medicine, a significant gap in studies conducted on women's bodies becomes evident. More specifically, there is a lack of studies addressing aspects other than those related to reproduction. Medicine as ancient origins, and it's very interesting to go to the definition in the past, when the context of reproductive function was defined as, I quote, a warm and moist creature with skin that is porous like a sponge, absorbing bodily fluids produced by food in greater quantities than necessary. So in the Aristotelian Galenic theory of humors, women, defined by the philosopher as crippled males, were depicted as unique sexual beings inferior to men, and their inferiority was believed to be due to their temperature, an essential characteristic of the hierarchical position of the four elements of the cosmos: air, water, and fire. So we had, for many years, an important gaps in the study of female biology that have dragged on over time and have determined the absence of important studies that distinguishes precisely on a scientific level the body of the man from the body of the women. Because of this, diseases such as endometriosis, vulvodynia have not been studied, which entail to date important difficulties in recognizing and attributing the diagnosis. Can the absence of studies of the female body, which have lasted for centuries, and inability to provide adequate care be considered a form of Obgyn violence? It's a question. Moreover, women's rights can be undermined and violated by additional forms of violence, including discriminatory and offensive language. Language possesses a strong impact in impairing human rights, and especially in the field of Obgyn and obstetric violence. Women are often targeted with offensive expressions and insults, while hospitalized or subjected to diagnosis and even consultation. Obgyn and obstetric violence might therefore also be considered as resulting from the discriminatory use of the language. Language in itself could play out as an additional manifestation of obgyn and obstetric violence. From a legal point of view, we know that the first country to legally define obstetric violence was Venezuela, with the Ley Orgánica sobre el Derecho de las Mujeres a una Vida Libre de Violencia, 2007. Article 15 states that obstetric violence means the appropriation of the body and reproductive processes of women by health personnel, which is expressed in a dehumanizing treatment, in an abuse of medicalization and pathologization of natural processes, bringing with it a loss of autonomy and the ability to decide freely about their bodies and sexuality, negatively impacting the quality of life of women. The Observatory of Obstetric Violence of Italia, together with other associations, promoted a survey entitled Women and Childbirth. And this survey is very interesting because it was demonstrated that 41% of the interviews could have declared to have received the childbirth assistance detrimental to their dignity and psychophysical integrity. 21% would have declared to have suffered physical or verbal abuse during childbirth, as well as other inappropriate treatment or treatment offensive to dignity. Because of the trauma experienced during labor and delivery, 11% of mothers reported that they preferred to postpone the decision to experience another pregnancy for many years. And 6% of mothers declared that the trauma was so severe that they declared not to have any more children. And so I can tell you that in 2016, a bill entitled Regulation for the Protection of the Rights of the Mothers and Newborn Child and for the Promotion of Physiological Childbirth was presented to the Italian Parliament. And I wanted to underline the Article 3 that identifies I quote, birthing assistant practices detrimental to the dignity and psychophysical integrity of the mother and the newborn, which are expressly prohibited except in cases of absolute and documented medical necessity. So it's a point of view of prohibition. And the Article 14 states that acts of obstetrical violence constitute action or omissions by the doctor, midwife, or paramedical staff aimed at dispossessing the women of her autonomy and dignity during childbirth. So this was a very important bill, and for this reason, the bill is not a law because the Parliament stopped the discussion. The norm aimed at promoting the necessary informed, free and conscious consent of the women to medical and pharmacological treatment during labor and childbirth. The right of women to receive a second medical opinion before being subjected to any invasive or surgical medical intervention would also be understood. The bill proposed, at least, the introduction of obstetric violence and gender violence, reflecting the legislative experiences of South American countries. We could also go on and to go on to other forms of non-regulated form of obgyn forced, that is the forced sterilization in Italy, okay, but I have to go on because I don't have time. And then there was also another form of we can imagine obstetric violence. And then it's the phenomenon very, very large and very too strong in Italy of conscientious objection during the determination of pregnancy. Our law 194 of 1978, Article 9, consent exempts healthcare staff and person carrying out auxiliary activities from the completion of procedure and activities which are specifically and necessarily intended to determine the termination of pregnancy and not by a system prior to and subsequent intervention. So the problem, the large and growing number of medical objectors created in Italy an insufficient number of medical non-objector and determines problems to the right of access for women to this law and to stop the pregnancy. And Italy was condemned by the European Committee of Social Rights, and this is
Yes, this is the right one.
Was condemned in 2012 and 2013 in two collective complaints, and I was a lawyer in that cases. So we demonstrate in many documents how much many women suffered for the situation. Many of them couldn't stop the pregnancy in the first 3 months, and so they had a very bad experience later. And then some of them, 2 or 3, died for complications to this for this impossibility to have the intervention. So Italy was condemned, and this I think that could be defined another form of obstetric violence, because in that situation a woman is alone and there is nobody who can care of her. And I think that this is a very important problem. Then possible solution. Okay, we go on. I wanted to underline the sterilization you told before, but we don't have time. I think that you can talk later about this perspective. We have another thing to underline. The new perspective of a new law, that is the delegation to the government on clinical trials of drugs, as well as the provision for the reorganization of healthcare professions and healthcare management within the Ministry of Health. And this delegation was based on gender-inclusive medicine, specifically targets issues pertaining to gender diversity in health and reproduction. So the perspective of gender in medicine was introduced in 2000 by the law 2012 number 3 of 2018. But this law, this delegation to the government, did not address Obgyn violence. We don't know if yet or the law talk of the same phenomenon with other words, because it may be, and we can ask Professor Cettin. And the law requires that medicine and clinical trials be oriented towards a gender perspective in research, experimentation, prevention, diagnosis, and treatment. It has assigned to the government the important task of adopting legislative decrees that directly impact the regulation of clinical trials. And the ultimate goal was to ensure the appropriateness of healthcare services nationwide, and more generally, to guarantee the full application and enjoyment of the principle of equality and the right to health with a gender focus. So this delegation to the government by a law, it's very important from a point from the principle, but I don't know if there is a realization or something is delegated to the hospital and or there is a general realization. So I asked Professor Cettin for and she'll answer. Two other important link between the Italian legal system and supranational I'm going to the end, to conclusion, supranational sources of gender-based violence. We can find a link in all the rules about violence against women. But here in our criminal code, in the new rules, we don't find a definition and something related to Obgyn violence. I think also to conclude that there is a very difficult situation also in Europe for women, because there is a very ideological anti-gender ideology that is spreading all over Europe. Yesterday, there was a very strong document by our Pope, and this document was against gender in general. We don't understand, we have to understand what the Pope means, but this document is the document in Italy by the Pope in Italy and in Europe, and is very, very strong and is very, very negative for this perspective. And so Obgyn and obstetric violence remain therefore in the background without any attempts to comprehend the additional form of violence within the general framework of violence against women. In conclusion, today, women are merely represented under the law scene in their bodily dimension. However, populism and often even politics tends to limit women's rights to self-determination in reproductive choices. The lack of sensitivity and of true awareness of the implication of Obgyn and obstetric violence severely impact on women's rights to give their consent when it comes down to choices over their bodies. In light of the above, the lack of legislative responses continue to lead to serious violation of women's rights. Lack of diagnosis, physical violence, verbal and despairing violence. Thank you very much. Sorry if I had to run.
Thank you so much, Marilisa, Professor D'Amico, for her presentation about Italy. For us, it is very difficult to find a connection between this topic because it's pretty new. So she made a very huge effort in finding like the links, because we started studying this topic, but it's very complex for us due to lack of data, case law, and so on and so forth. So we're kind of trying to find ways to grasp more into the topic, and so thanks to her as well. I will now give the floor to Professor Cettin. So we're moving to the physician side, and we are very happy to have her with us. That we have a different perspective, because it is coming from a different field of research, finally. So the title of her presentation, while we're setting up the PowerPoint, is Reproductive Violence, Changing the Paradigm toward reproductive health of individuals. Professor Chuti, Department of Biomedical and Clinical Sciences at the University of Milan, but also, and she's working at the Hospital Mangiagalli as Policlinico, as we said earlier. So I'm very happy to have her with us, and I give her the floor for her presentation.
Okay, thank you. Thank you very much, Costanza, and thank you all for being here. And thank you to the colleagues, colleague of Costanza and Marilisa, not really clinicians like me and some of my colleagues that are here, but actually colleagues in this team from Canada. So that was very great to listen to you today. Of course, we have a really different perspective that we start from. And indeed, it was awkward in a way, maybe it's not the correct word. I mean, talking in English about these topics is not easy because the nuances are not the ones that I am used to in a scientific field where I have a very known language and wording. But talking in English about these topics is not so easy for me. So I'd be careful not to say wrong words, but I appreciated very much what Marilisa just said. I mean, you went to sort of an idea of how I have it in my title, but like the paradigm is changing in general in medicine, but of course in this field we're talking about today, because it was interesting to see how, you know, the fact that women came to deliver in the hospital that happened maybe, I don't know, 80 years ago. Maybe I have some midwives here that know probably better than me when it happened in Italy, but there was obviously a change throughout the world that made it so that women were put in a really very different situation than home births that had been going on previously, with the midwives going home and having home deliveries. I mean, not that everything was good then, because obviously we know that there was a lot of unsafety. So the reason to bring the birth to the hospital was to avoid maternal mortality and perinatal mortality. So for example, now in Italy, we have very, very low maternal mortality rates, one of the lowest in the world. I don't know how much it is in Canada, but I know that in the States, it's much higher than in Italy. So in Italy, in Lombardy in particular, we have mortality rate that it's around 5 women die each year. Sorry, not each year. 5 women die for 100,000 deliveries in Lombardy, which is one of the lowest in the world. So it means that we are putting a lot of attention on protocols and on maternal safety. Obviously, when you do that, you have to consider that we are in a situation where we have to balance humanization of giving birth. I mean, humanization, maybe we say it in Italian, but you know, giving all the appropriate attention to what we want to. We know we want to give attention to this process, but then on the other hand, we have to be sometimes handling very urgent and emergency situations where sometimes it's not so easy to have a good communication. So my presentation today, I'll go quickly to something. This is a definition. While you were talking, I made some changes. So for example, I put in red here 3 points that are what I'm really thinking a lot about in the last year or so. So it's the points that are not so much physical abuse or even not a very strong and very well perceived forms of violence where we don't have any doubts, but what we could maybe not feel, and maybe that a woman would feel, and that we have to become more aware of. Because really we have to think that there are some cases of real obstetric violence in the sense that not real, cases where there is also an intention in a way. But probably what we need to, instead of become aware of, is where do we put the limit for our culture, for what is true and good for us, and should we ask the women what they want really, or do we have to decide what the women need to want? Okay, because this, we have to listen to what they say. Otherwise, it's just my position and your position and her position, but I mean, it's their needs that we want to listen to. Okay, so let's go back to informed consent and shared decision making. And then there is the problem of communication and how. So there are a lot of definitions. These are definitions of what, in general, we would like to have. Autonomy in decisions, being beneficent, non-maleficency, and justice. Okay, obviously this. I was talking while we were here with my with the young colleague that is a resident with us, Francesca, and she was telling me, we don't have time to do all this. When we see a lot of patients, we have maybe 20 patients in one morning, and you have to explain everything. It's not so easy to go through everything. We know that many people don't already have all the ideas. I mean, they need a lot of time, and all this time is not. I mean, it's a public health system, it's not always there, but the objectives are to share, which is speak, help, assess, so, speak and help to understand, then assess whether the person has understood, and then reach a decision with her or with the couple and evaluate the patient decision. Okay, this is the perfect world that we have to aim to. Okay, in Italy, informed consent has an article and a definition, and it's very important to realize, also to answer to my colleagues, that we have to put this into the clinical charts. We have to say we have used this time to communicate. So maybe it's half an hour, maybe it's 1 hour, but it's important to devote this time. Every patient counts. Is not only the oncological patients or the patients with very bad things that we have to devote time to, but we have to devote time to all of them. But then there is a problem with resources, of midwives and doctors. I look at my midwife there. We know very well there is a problem. It's a public health system in Italy. It works, but it doesn't have so many resources. Right now it's becoming. So what about pregnancy? Okay, again, we have to think about mother and fetus and neonate, of course, well-being. So we have to start early to describe and discuss the potential scenarios. And we have to change this paradigm of many of my colleagues that think that since the patient is pregnant, she has to deliver somehow. And so therefore, I'm the one who makes the decision for her delivery. No, I mean, this has to be changed. We have to give the patient all the information, but also to accept that she can have different ideas about some parts of this process. And this is not easy in Italy to change, this idea of a different idea of the woman. I mean, the first response would be from some of my colleagues, well, if she doesn't like this, she has to go to another hospital. We just don't change our mind because she thinks differently. And obviously, there is also a lot of concern about the medical, how to say, con le cause medico-legali, comunque, il contenzioso medico-legale. I'm blocking on the. Anyway, there is a lot of issues in Italy because many women sue for anything. Yes. So I don't know in Canada, but in Italy, this
medical liability.
Medical liability. Okay, I couldn't remember the word. Also, it's very difficult during pregnancy, although I think it's very important, but it's very difficult to explain everything to a mother-to-be. because there are so many things that go on during pregnancy, so many factors involved. You may have very, very different scenarios that are related to a number of factors. I mean, this is just a rough, very, very rough idea. So anyway, just even the process of labor can be spontaneous, can be induced, but you can have an elective cesarean section or an emergency cesarean section. You can have potential complications during vaginal delivery, potential complications during cesarean section, postpartum hemorrhage. You may eventually even have hysterectomy, but eventually you can even have maternal death. So do we really explain this to a mother? No. Would you like to stay with a doctor that tells you at the beginning of pregnancy, well, you can die, okay? Because on the other hand, we want to empower the woman, make her think that it's a good experience, because we know that this will diminish problems. Like, for example, we know that excess of stress increases the risk of preterm delivery. So we have a responsibility, but it's very difficult to balance this in wording. You know, particularly if there is not a lot of time, and maybe not the same doctor or the same midwife meets the same woman every time, because in the public system, this is very difficult to maintain always the same doctor unless you go private, but that's a different thing. So, okay, so, and also, you know, there is tension. There is tension because it may cause conflict between a woman and her caregivers. Because, for example, when we talk about birth plans in Italy, this is a word that most of my colleagues don't want to even hear, the word birth plan, il piano del parto in Italian. It's considered just even saying this, it's like, you know, what are you talking about? You know, so there are things that need to change, but we have to make it in a way that that is sustainable in a way. So there are not so many data about surveys and about what women would like, you know. But for example, one of the things that has been investigated is what is the knowledge about what can happen during delivery. So you can see that the highest level of knowledge, the different columns are only the difference between first delivery and second or more than second delivery, so primiparous and multiparous. And you can see that the knowledge, most women know that they could go through a cesarean section. Okay, this is the knowledge. Also, I imagine also for you, when you talked before, you know, you were mentioning why wasn't cesarean section performed? Well, this is, to me, that was not very nice to listen to, because cesarean section for us is very easy to perform. It's the easiest thing in the world, right? I look at my midwife, one of the midwives there. It's the easiest thing. What we are trying to do in Italy is not to perform cesarean section, because cesarean section is not a good thing for the mother and not even for the baby. So myself, I'm doing a lot of work together with other people to decrease these rates. So it's not the cesarean section is the correct answer. But see, the problem is that cesarean section is the only procedure that is known by at least by these women that were interviewed. Forceps in Italy is not used, but was known a little less. Vacuum was known only by like 70% of women, and episiotomy was known by 50% of women. So if you don't know that something can go on, of course, then you can have a problem when it happens. Because one of the most common complaints I hear from women that write to the URP, we say now to there is an office in all Italian hospitals about the relationship with the public. So they write, many of them, they complain that an operative delivery was performed and that they did not receive enough communication about this. And that's wrong. Okay, this has to be improved. We need to inform women, but again, you know, and I look at my midwives, often we don't provide many information about what can go wrong, because we prefer to give the woman the idea that delivery is a nice thing, that everything will go well, and that you will have a very, pink and with butterflies and with everything, everything goes well. But things not always go so straightforward, so maybe they only have some change, but we need so given that all modes of delivery carry risk, there is ongoing discussion about how obstetrical providers can ensure that patients are well informed about their options, well informed before and during and after, because it's communication that has to start well before, during, and then again after. And it's very, very important, because that's the first thing to have a good feeling between what is happening. Okay, well, I want to mention something that I think it's very important now. I added now, just this afternoon, this slide. So we are working on new Italian guidelines on pregnancy care, and they're being revised. And there is a part that has been included. It was not included before. So there are some questions with the answer that are that I didn't report now here. So you can see that it's very important. This was put in the guidelines that all Italian obstetricians and midwives have to follow, will have to follow. What are the preferences and needs of women regarding communication? And again, what are the contents, type, and timing of communication in pregnancy for conscious choices about this and that and that? So this has been put in our guidelines that will become used now. And but one of the things that came out is that there is need for further research on these topics. There were very few papers investigating these aspects and investigating what really women want to know and how they want to be informed and so on. So birth plans, are they useful or not? I think yes, but not only me. But what are the providers' attitudes, beliefs, and practices? Again, as I told you before, while expecting parents should focus on how to feel safe and confident as patient, and they need to have a lot of information about this. On the other hand, providers' perspective on the matters may sometimes be at odds with those benefits. In one study, 77% of physicians and 22% of midwives, not so many years ago, did not recommend, birth plans. And nearly 1/3 of the providers thought birth plans were predictive of adverse obstetrical outcomes. They thought it was, the feeling of healthcare providers is that the birth plan is required by women that don't trust the healthcare system. Instead, this is wrong. This is the wrong attitude, because communication needs to be done, and you need to be not just communicate what is going to happen, but you have to be bilateral. So you need to try to understand what the woman would like to have. So so there are examples of what you can discuss. It's also, about a number of issues. So which person you want to have with you, how you want to have pain relief. So you have to have the options. So not all the options that are, for example, listed here would be available in every place, but we have to do our best to provide the information and to allow the women to decide about this. So what's the goal? The goal is discuss, start discussion, and determine what is safe. The surveys, again, satisfaction surveys, what is the result? Oh, Marilisa, I want you to look at this. You mentioned the study before, a survey, but I think the study that you mentioned is the one that preceded this one, and the one that you mentioned had a lot of resonance on the newspapers. But it was not an epidemiological study. It was this association asked women if they had to, if they wanted to respond. So, because so they asked a response, so people who responded were very likely those that were not happy. It was not based on all women that delivered in a certain hospital. So this was done by the Italian Society of Gynecology and Obstetrics, and it was so it covered 117 centers in Italy. We participated, for example, I was at Puzzi at the time, so you can see 13,000 and more women. So it was a very large survey, and in general, women were generally. I'll show you now the data. Were generally satisfied, but they said that information was lacking sometimes and pain control was not always performed in the best way. These were the type of questions that were asked. Now I'm going to finish in a few minutes. So what I want to show you is that in this survey, so in Italy, overall, 3% of these women felt unsatisfied. There was a lack of information in 4.6%, and a lack of pain control reported on general in, I think it's written 8% approximately. But the most unsatisfied women were those that had a vacuum-assisted delivery or an emergency cesarean section. Again, showing that we need to improve the information about possible eventual emergency situations. Also, I would like to remember, though we're talking about violence for women, and I agree that until now, we now have in Italy a man that is going to deliver soon. I don't think he has delivered yet, but he changed phenotype. And he was already pregnant. Now is she. No, sorry, she that now is a he. Okay, so I don't know if it's going to be the first in the world, but it's going. It was in the press in the last months. So anyway, he's going to deliver looking as man. Okay, with the uterus and the baby in the uterus, but so it will be interesting. But anyway, apart from that, in general, most partners are male. And so, but in general, for partners, we have also to consider the partner's satisfaction somehow, because we are indeed creating a triad, we say in Italy. I don't know if you use the same wording. And also the partner's experiences of childbirth. It has been studied a little bit, and also the partners asked for more information. So let's think about this topic and how to measure satisfaction. Okay, just to say that we are doing a satisfaction questionnaire now at Mangiagalli. I show you the questions. So we are looking at some easy things that we ask the women about kindness and availability, about the feeling of empowerment they had during the delivery, whether communication was good, whether there was appropriate relational information. Now the translation is not easy, but communication in case of operative delivery, appropriate communication in case of episiotomy. And did you feel any form of disrespect? So this is one of the topic questions. It's in the middle of other questions. We didn't want to show it that it was the only purpose. And did you perceive enough attention to your emotional needs? How do you evaluate pain control? Did you feel in control? Okay, was skin-to-skin proposed? And did you perceive enough support during the skin-to-skin procedure? And what is the general assessment of the healthcare you received? And general evaluation of your delivery experience, and would you suggest our birth center to your friend? So we just started this. We have very, very few responses in general, and we aim to do it in all women, not just some of them, all women for a certain period. And so that the main things we are seeing is that they would like to have better communication, better pain control, we want I would like to know, in any case, if there are some ideas of how we could improve maybe these questions, if there are some key questions that we are not addressing. So take-home message is what I already told you, but is what we all want anyway, to ensure better positive experiences for these women. Thank you.
Thank you so much, Professor Chetty, because, and actually this change of plans worked very well, because we actually needed to hear something from a physician after all the questions that were put forward. And now I have to give the floor to myself, actually, which is kind of weird. And I'll try to be brief. Also, in light of the fact that we will have this publication, so there's no need for me to hinge on all the issues that thank you. Okay, so I'm going to be brief for two main reasons. The first one is that all the reflection on the lack of a consensual and universal definition of what it is, obstetric and Obgyn violence have been already discussed. I would say something about what's going on in Europe, because actually, at least at the level of soft law measures, and we had some adequate, or at least some insights that are interesting in the perspective of ways, new ways to tackle this phenomena. And actually, I was in reviewing this presentation, I found myself much more interested in linking this topic with a intersectionality on one side, and that was part of the reason why it was very interesting in Dominique analysis, and also on forced sterilization, because I don't know why, but actually before coming to Montreal in December, I was looking for gathering data on it, and I didn't find much. And now actually I found a lot of cases, not in Europe, but I think that this is another kind of issue that we might want to pursue. And I think it would be easier actually to tackle this form of Obgyn violence rather than all the others that Audrey, for example, talked about, in which, you know, the boundaries between negligence and non-negligence is a little bit more blurred. And I think that that is the very big challenge in actually establishing a liability on a civil side or on a criminal side. So I would like to start with the news, because actually it's pretty, this is a news from January 2024 in Serbia. There was this case which I found very interesting, because this case get together two aspects. So it's a case of Obgyn violence, plain Obgyn violence, and second of all, because it is against a Roma women, meaning a minority women. So we have like, we couple these two perspectives, so the intersectionality perspective with the form of gynecological violence. Of course, I'm not going into the details. You here have merely the statement released by the president of the European Roma Center, because in Eastern Europe, the forced sterilization, this is not a sterilization, but we still have a lot of issues regarding Roma women. But this was actually interesting because it's recent, because it gives us an example, a true example of what might happen. We don't know yet anything regarding the follow-up, meaning how this case will be brought to court, which court, whether in domestic court, whether afterwards supranational courts, and in this case it would be the European Court of Human Rights. But things I think it would be interesting to keep monitoring, because maybe since we lack case law on it, maybe it would be interesting to see how things will develop. So this is actually the report Professor Abbraccchio was mentioning at the very beginning, so I'm not going to focus on it once again, but just to say that we all agree that maybe our goal will be to actually gathering our forces and shedding lights over this phenomenon across our two countries, but more generally global. These are some data that I managed to gather. It wasn't easy because it's a neglected phenomenon, it's an underreported phenomenon. So as forms of violence against women, this is something that is very common. So if you can tell, I'm not going to read through all of this, but actually these data are pretty clear. And the interesting part is that they are about countries that are not low-income countries. And I'm saying this because during my research on forced sterilization, one of the reasons why this form of Obgyn violence is perpetrated is related to poverty. So very often low-income women are the main victims of forced sterilization alongside indigenous women, Black women, minority women, meaning women belonging to ethnic minorities. So that these things that we still have a lot of data, or even including for a form of forced sterilizations in these countries, tells us a lot about the imbalance in terms of economic resources that we have. So what's interesting in Europe, but I don't think it's merely a European initiative, but I focus on Europe, is the fact that thankfully we do have a lot of effort by NGOs in gathering data, in working on grassroots or doing grassroots research in order to tell us something more about this phenomenon, since we do not have case law. As a consequence, we do not have laws, and so it is very difficult to find data. Women are not always willing to tell and talk about their experiences, and this is another common trait to all forms of violence against women. So these are mainly two examples that I made it to find. One is in France and the other one in Croatia, and feel free to check it out, because if you Google it, you will find they are both very interesting and pretty recent. As I told you earlier, what we do have right now are merely in Europe soft law mechanisms, and so we do not have binding instruments. Okay, so I'm talking about, of course, the supranational level, meaning international human rights law. And the problem here is that basically there is a common trend in Europe, and when I talk about Europe, I'm covering not merely the European Union, I'm talking about the Council of Europe, so I'm talking about 46 member states. Besides the fact that Russia is not anymore part of the Council of Europe, but I think that this argument could apply perfectly even on Russia. So we are talking about a huge area. And there is, yes, a trend to refrain from actually interfering in this aspect. And this is interesting because when we talk about international human rights law, the very key feature, the ontological feature, is to allow an interference in order to protect human rights, even in the private sphere, and to safeguard human rights. And what we're witnessing here is exactly the opposite trend. So it's like we are endorsing like a liberal approach, meaning a refrain, an absence, lack of intervention in what we think is too intimate, too private, to not deserve public intervention. In terms of what is going on right now in Europe, of course, these are, as I'm not going to focus on here, but these are the categorization of forms of violence related to reproduction suggested by the Council of Europe. So this is not an abstraction, this is a choice made by the Council of Europe in 2018, so not, 5 years ago, and we do not have anything about it ever since. So I'm not saying that 2019 is a long time ago, but it's not that recent actually, in light of the fact that this is a phenomenon that instead is in need to push and to move forward in the analysis. So in terms of what is it, Obgyn violence in the perspective of the Council of Europe, these are some of the forms. And I highlighted in red forced sterilization and forced abortion and female genital mutilations, because in the perspective of the Council of Europe, these are the major and kind of exclusive forms of Obgyn violence. And this is the same approach endorsed, for those of you who know the Istanbul Convention very well, that the very first treaty that we have here in Europe about violence against women mentioned. So this is also, and there is no absolute reference to any form of more general. I'm talking about an umbrella term, like saying that there might be forms of violence against women related to sexuality and reproduction. So there is no need to have an exhaustive list of forms of violence. But actually, what do we have in the Istanbul Convention is a specific reference to these 3 forms, and these 3 forms also influence a lot the action of the supranational bodies operating within the Council of Europe, because actually, if you look at the European Court of Human Rights case law, I have the slides. So this is another, okay. So if you take a look at the major case law of the European Court of Human Rights A, we do not have so many case law B. When it comes down, for example, to female genital mutilation, we have like a bunch of cases, handful of cases, and almost all this, regardless of the fact that the Court of Strasbourg is there's no problem in saying that female genital mutilation represents a form of inhuman and degrading torture within the meaning of Article 3 of the Convention. The majority of these cases were declared inadmissible because they also were intertwined with migration issues. And so when it comes to migrations, there is this, hands-on approach by the European Court of Human Rights and saying, well, here, this is a matter for the state, so there is wide margin of appreciation, so I do not have to interfere. These are some other cases in the event some of you might be willing to, dig a little bit more into the issue, but these are the only cases. So I did a research on the HumanHall database, and the cases that are more interesting are those about forced sterilization, because they are pretty recent and because they ended up with a finding of a violation. And I think especially Suarez versus Portugal was very interesting, even though I'm not sure how many of you are familiar with the conventional rights, but here the violation was found from the standpoint of Article 8, which is the right to that safeguard private and family life. So we didn't went too far to say that forced sterilization is a form of inhuman and degrading or torture, for example, meaning Article 3. So yes, a victory, let's say, but we're still not really satisfied with the outcome, because when it comes down to forced sterilization, I'm not entirely sure that is a matter entirely of private life, since we have a violation of the physical integrity of someone from a constitutional perspective. We would have to take into consideration, I'm referring to the Italian Constitution, Article 13, which is the right to physical integrity. So actually this interpretation is a very let's say, smooth reading of the practice. we will see. It's very difficult, we know, to bring cases to European Court of Human Rights, but still we are waiting for something more. In the European Union, no case law, so no surprise. There is nevertheless, especially after the Dobbs case, so the judgment of the US Supreme Court, a new kind of movement in favor of strengthening sexual and reproductive rights. So there is still this proposal pending to amend the European Union Charter of Fundamental Rights to include the right to safe and illegal abortion, which is something that we could even say, well, this is nothing directly to do with gynecology, Obgyn or obstetric violence, but in a way, I think that it might pave the way to embrace a more, like, to ensure more awareness towards the fact that even reproduction, even sexuality and all related rights do have the dignity to have a say and to actually be safeguarded explicitly in a convention without leaving all the roles to courts and domestic judges to interpreting, you know, provisions that in principle, especially when it comes down to fundamental rights, are, yes, sometimes easy to interpret it, I mean, widening the scope of application, but sometimes they don't. And we would like legal certainty instead of judicial discretion. So this is the civil law part of me who is speaking, but actually we aim for equality. So that was the goal of having a more sensitivity towards this kind of right. And it's actually, if we think of what happened recently in France, actually, I mean, I remember that I was very skeptical about the possibility to have an explicit safeguard of the right to abortion in the national constitution. They did it. And it's like it was a groundbreaking news because globally, the only treaty that explicitly mentioned the right to abortion and the right to safe and legal abortion is the Protocol of Maputo in the African continent. So we think we are very progressive, maybe we don't, we're not so progressive. So here, I mean, I'm not going to, this is something from the comparative perspective, but it does not add more in terms of details about what we said already in terms of the lack of specific regulation. Yes, we do have a lot to learn from the Americans. This is something that we said already, so I'm not going to say something more, also because we will have two brief presentations regarding Argentina and Venezuela. The only thing that I would like to mention is that in 2023, there was this very interesting case against Peru, which was brought for the very first time before the Inter-American Court of Human Rights. And this case the plaintiffs are more than 1,000.244, something like that, of women that was forcibly sterilized during the Fujimori regime. And we will see how it goes, because actually the domestic court, the Supreme Court in Peru blocked the case. So now we are at the time in which we need to see how will the supranational procedure will end up, because the domestic responses were actually not satisfying. And about Argentina, Camila will say something, because actually in that case, we actually had the very first legal definition of domestic violence, which is very interesting to say. I'm going forward. Okay, so intersectionality, I said it at the very beginning. The only thing that I would like to add is that if you do a little bit of research, unfortunately, when it comes down to forced sterilization, intersectionality is really important. So, for example, in Sweden, we know that for racist motives, for eugenetic motives, until the 1976, forced sterilization was like practiced without any kind of issues. We also know that in terms of the comparative perspective, these are the major victims of forced sterilization, and Dominique said it already at the very beginning. In terms of what happened, what is going on in Europe, and I very much agree with what you said, Dominique, about the role of criminal law. We say criminal law should be the extrema ratio, meaning we should resort to criminal law only in case no other means is effective. And actually, the problem here, when it comes down to forced sterilization, is that we do have some cases of criminalization. Malta is, I mean, I highlighted the years of the most recent ones, but we also have cases in which forced sterilization is allowed in France, for example, for under exceptional circumstances, they say, women with severe, tell me what you mean by severe mental disorders, can be sterilized. So I was very surprised. Also, in the United States, the situation is kind of surprising. Eastern Europe is, I mean, for us, Eastern Europe, we know that in Eastern Europe, Roman, and disabled women are very, unfortunately, often forced sterilized. But I actually did not expect about the US. Peru, I told you already, China, and here yet again, intersectionality, and even more than intersectionality, I fear that these are policies towards assimilation, meaning forced sterilization is kind of used to tackle and contrast the existence of ethnic minorities. And you do that, hinging on women is like the gender reading of genocide is exactly the same reasoning underneath. So from a gender perspective, it's a very interesting topic to highlight. We're going too far. I mean, let's see. Okay, so these are, to conclude, let's see, what time is it? Okay. These are kind of my suggestions, the thing that I think I would like to work on more that I think it would be suggested to reflect on. And certainly, I think that what is missing, at least in Europe, is a stronger, I mean, the establishment of a stronger link between reproduction and violence, because these two aspects are very widely separated. And this is one of the reasons why we do not talk about object violence. We talked about obstetric violence. We had a very interesting conversation, Audrey and I, when I went to Canada, because here we only say obstetric violence. No one used the word gynecological violence or object violence. Because the idea is, because it's very difficult to let the concept enter in the public debate, and it's easier to use a narrower word, because when you talk about obstetric violence, it seems that the scope is narrower. So you're kind of condemning less types of practices rather than you can talk about gynecological violence, because yes, Josie, okay, because it is a more threatening word, okay, so that, as always, there's a reason why you use some words and not others, but actually, this is another thing that is very interesting. Yes, of course, we should ask ourselves, I think this is something that at the UN level was discussed, meaning whether object violence is torture, depending perhaps on the types of, but since, I mean, also when we heard about the cases that you discussed, well, actually, maybe torture in human treatment, maybe yes, maybe it's too strong to say, but it's a question mark. It's something that we could discuss, because the UN commissioner was actually saying, yes, it is. So we should say so. And I would like to finish. I'm not going to read it. You have it on your screen. This comes from a French documentary that I found very inspiring on this. And I'm sorry I had to be very quick, but I hope to have the chance to discuss with you even further about this topic and with the publication. And I thank so much the editor, which is in the back. Tommaso, thanks for coming, because we would like to, ensure a wide dissemination of our work and our research. And I thank so much for the attention. Okay, it's always me talking, so I'm always bored about hearing my voice talking. So I'm welcoming here Justine Barbara here. She is the other physician, so we're kind of mixing the two sections, but it's good. So her presentation title is Obstetrics and Gynecological Violence as a form of gender-based violence. Of course, her perspective will be very different from mine, even though the titles are quite similar, which is very interesting. She's a dearest colleague of mine, and she's also a friend of mine. So I'm 2 times honored and happy to have her with us, and I leave her the floor.
Good afternoon, everybody, and thank you, Costanza. No, it's working. Okay. Good afternoon, everybody, and thank you, Costanza, for your introduction, for inviting me to be here today. It's a real pleasure for me, and thank you also for the colleagues from Canada and the great debate we had at lunch. In this brief presentation, I am a gynecologist, but I am also the head of an Against Gender-Based Violence Center, addressing sexual and domestic violence. And our center is located in a gynecological division in our hospital. So I every day deal with cases of gender-based violence, sexual violence against women, intimate partner violence. So in this brief presentation, I would like to give you an overview, although not exhaustive, of how the phenomenon of obstetrics and gynecological violence is placed in the context, in the framework of gender-based violence. And I'm going to summarize the position of many societies and political organizations that have spoken out on these issues, and also try to offer points of reflection, because there are many aspects that are still not fully clarified and on which I have to be honest with you. There is a little bit of controversy, especially in the medical field. So when referring to violence against women, we are discussing all forms of gender-based violence that cause or are likely to cause physical, sexual, psychological, economical harm or suffering to women. And of course, this kind of violence includes threats of such acts, coercion, deprivation of liberty, whether they occur in public or private life. And this is exactly the definition given by the Elimination of Violence Against Women Declaration, published in 1993. And violence against women, so, is a form of gender-based violence committed against women because of their gender, and so that disproportionately affects them. And this is the definition acknowledged by the Istanbul Convention, Article 3. So the question now is whether obstetrics and gynecological violence is sexist in nature, reflecting a patriarchal culture that still dominates the society, including also, of course, the medical field. I don't know if I have the right answer, but I will try in this presentation to give some points. Many aspects, in my opinion, of obstetric violence can be classified as gender-based, as already
this is your quote, Audrey, this is for you, as Audrey has said, as correctly observed, as said previously, to this date, a single cisgender man has given birth. So this type of violence not only disproportionately affects women, but also exclusively affects them. Second, the lack of respect for women's equality and human rights, which can be at the root of obstetric violence, is one of the main causes of the phenomenon of violence against women. So in this way, in this perspective, obstetric violence and gender-based violence seem to have the same root cause. And third, last but not least, patient, women, caregiver interaction often involve unequal power dynamics, where the caregiver holds power, knowledge, authority on the patient, and the patient is in a submissive position, in a vulnerable position. So this power imbalance, which also characterize acts of gender-based violence, can leave the woman in a submissive position and disempower women. The United Nations General Assembly identified a number of gender stereotypes as root causes of obstetric violence. For example, these stereotypes include discriminatory national laws or practices that require spousal or third-party consent for women's medical treatment, as well as, for example, harmful gender stereotypes related to reproductive health that limit women's autonomy and agency, beliefs about women's decision-making power or their natural role in society and motherhood. And of course, for centuries, childbirth and motherhood have been viewed as a duty for the woman, rather than just one of many potential roles of the woman. So women were expected to contribute to society by reproducing, dedicating themselves to family, husband, children. And we all know that these stereotypes arise from strong religious, cultural, social beliefs, and also ideas about sexuality and childbirth and motherhood. But try to fix to the Bible's word that have been manipulated to suit the male's gaze. The phrase, for example, with pain, you will give birth. This is an example of this pervasive thinking in the society. So I think we can say that obstetric violence can be viewed as a form of gender-based violence, resulting from a patriarchal culture that privileges men and subordinates women in all fields in our societies, including the public and the private sector. Very often, the focus is on the health of the baby, with little regard for mother's physical and emotional well-being, and maternity services are not exempt from these patriarchal roles. Women very often are told to be happy about a healthy baby, and their own physical, emotional health may be of little value. What do the political institutions say? I go through this slide very quickly about including obstetric violence in the framework of gender-based violence. Both the United Nations General Assembly and the European Parliament have identified obstetric violence as a form of gender-based violence. So they say, yes, it is a form of gender-based violence. And also the European Parliamentary Assembly reaffirms its commitment to promoting gender equality in all areas, which help prevent and combat all forms of violence against women, including, again, obstetrical and gynecological violence. Also, on the other hand, the Istanbul Convention of the Council of Europe does not specifically address obstetric violence as a separate form of violence against women, and has already as already Costanza said, although the Istanbul Convention does not explicitly mention obstetric violence as a form of gender-based violence, it does include forced marriages, female genital mutilation, forced abortion, and forced sterilization. Thus, just to be clear, and as we have already heard, when we talk about obstetrics and gynecological violence, we refer to any disrespectful or abusive attitude of healthcare workers towards women in the provision of sexual, obstetrics, gynecological, reproductive health services. So these include gynecological examination, pregnancy, labor, abortion, fertility treatment, breastfeeding, counseling, contraception, and so on. So obstetric violence is an umbrella term that covers a really wide range of practices that are difficult to classify into a single typology. And this is the real question, in my opinion, the main point. Are all these different forms of obstetrics and gynecological violence gender-based, or maybe only some of them? In other words, can all practices under the umbrella term of obstetric violence can be considered sexist in nature? In order to organize the various practices that fall under this umbrella term, I have tried to group the main harmful practices reported in the literature regarding this argument into 4 categories. Of course, these 4 categories are not exhaustive and may overlap, but generally we can have verbal violence, including sarcastic, sexist comments, such as, for example, you didn't cry when you did it. You didn't shout when you did it. Why you shout now? Why you cry now? Okay? Scolding, humiliation, insults, intimidation, and so on. We can have also physical violence, which means in this context, unnecessary surgical incisions, such as, for example, episiotomy, cesarean section, and so on, rupture of the membrane, for example, pressure on the abdomen of the woman, but also omissive conduct that causes pain, such as, for example, failure to give the woman anesthetics, painkillers during the labor, etc. We can have practices related to violation of consent, no informed consent, as we can have said previously, and abuse of authorities. This is an important point in medicine, the paternalistic medicine. So I know, because I am the physician, and you, patient, don't know what we are doing, okay? And also the experiences and feelings that women have about what they have been through can be of different nature. We can have, for example, some women may feel dehumanized, disrespect, or abuse. Others may feel emotions for bad violation, non-consensual cutting, insertion of fingers into the vagina. And finally, women are also reported feeling powerless, with a sense of impotence for misinformation about intervention. So obstetrics violence is really different. It can take various forms, can be active, can be passive, can be related to health system condition. But what we have to take in mind is that all these different modalities can impact women's health, their experience of childbirth, their right to be respectful, dignified, the right to a human care during pregnancy and labor, and also as physicians, as midwives, we have to take in mind that pregnancy and childbirth are a unique experience in a woman's life that she will never forget. This is an important point for us. So, turning back to our original questions, can all forms of obstetrics violence, despite the differences, be considered as gender-based? Is it appropriate to make a generalization rather than distinguishing between specific situations, different modalities. In other words, is a one-size-fits-all approach appropriate in this case? I think no. I believe that the one-size-fits-all approach doesn't work in this area for 3 reasons, but we can also add several reasons. First, it doesn't help women to understand and overcome what has happened to them. It does not help health professionals or policymakers to develop useful strategies to overcome this phenomenon. And moreover, it may foster feelings of mistrust towards the health system. And in my opinion, it's not really appropriate to make a generalization because in the field of obstetrics violence, we can consider 3 broad categories of action or passive action that can overlap but remain distinct. We can have acts of gender-based violence in which we can recognize typical dynamics of female victimization, such as, for example, sexist comments, verbal aggression, misogynistic attitudes, forced sterilization, forced abortion, lack of respect for women's equal status, for their dignity, medical paternalism, and so on. But in contrast, we can have situations of institutional violence, which is perpetrated by healthcare professionals but is caused by systemic issues such as overwork, lack of privacy, and this kind of violence could also affect men. Of course, not in maternity services, but in healthcare provision. And third, as a gynecology, unfortunately, I have to recognize that medical malpractice exists. It's a reality, and we need to deal with it. We have medical malpractice when there is inadequate consent to medical procedures, even when correctly performed, or medical procedures performed without medical justification. This is medical malpractice. And why, in my opinion, it's so important to not generalize? Because we have to consider that different forms of obstetrics violence may require different approach. To address situations of violence against women, of gender-based violence, of obstetrics violence gender-based, we need to promote policies that ensure gender equality, combat gender stereotypes, empower women, and of course, train healthcare providers on gender issues and equity. On the other hand, in case of institutional violence, we need to work on another level, not on gender issues. We need to work on the organization of maternity facilities at the management level, addressing health system issues such as understaffing, high patient volume, low salaries, long working hours, and also we have to promote elements of respectful care. In the case of medical malpractice, we need to train physicians to the use of only justified medical procedures. And of course, as Professor Cetin has already said, the importance of consent in obstetrician is crucial. Furthermore, as we have already heard, when addressing solutions for obstetric violence, we have to take in mind that many healthcare practitioners are resistant to the use of the term violence. This is a fact. This is a reality. We need to deal with it. Because if there is a resistance, because violence in our culture means an intention, and this is difficult to change this mind. Okay? And if there is a resistance to address an issue because the term violence cannot be used because it is a taboo, it becomes more difficult to implement effective strategies. Going to the conclusion, I just would like to summarize the points raised in this brief presentation. in my opinion, we need to make a distinction if we want to correctly and properly address this issue. Make a distinction between different practices and distinguish between gender-based violence, institutional violence, and medical malpractice. And we need to start to continue a constructive dialogue with healthcare professionals. This is crucial. We need to be sensitive, of course, to gender-based issue and try to train doctors on gender stereotypes, equity, compassionate care. It's not so easy, but we need to. And in our profession, we have to balance, as already Professor Cecchin said, between the principle of autonomy of the women and the principle of beneficence that involves also the fetus, the newborn. So it's not so easy, but we need so. Thank you.
I'm trying to, because we had one of our panelists who is online, but she has a video. So I'm trying to, Francesca, do you hear me from home? No, okay.
Hello, everyone. I'm very happy to be here. The topic I would like to address today is certainly a very sensitive but often overlooked one in our country and beyond. My purpose is to link the right to health and its implementation with respect to the female universe, and in that context to highlight the case of obstetric violence, which does not only concern the medical approach, but can and should also involve the legal one. My reasoning starts from the right to health, a fundamental right that every human being should be able to enjoy, independently of his or her sex, gender, race, language, religion, and economic and social status. Unfortunately, we are all well aware that the universality of the right to health is, as things stand, still far from being fully achieved, because this right is affected to a greater or lesser extent depending on the place and time in which we find ourselves by a series of determinants defined as else determinants, which make the enjoyment of this right often problematic, if not impossible. Else, in fact, by its very composite nature, is subject to the effect of multiple variables. The determinants of health are manifold and can change over the course of a person's life. To simplify, we can say that they include personal behavior and lifestyle, social factors that can be an advantage or disadvantage, living and working conditions, access to health services, general socio-economic, cultural, and environmental conditions, and of course, genetic factors. But what is else? When can we say that our country purposes virtuous policies, and when can we believe that our choices are good for our health? The new definition of health provided by the World Health Organization in 2011 says that health is the ability to adapt and self-manage in the face of social, physical, and emotional challenges. Health, then, is viewed as the capacity to adapt and the possibility of self-determination, but it is necessary to ask whether this is the case for each and all of us, or whether instead there are determinants of health that inevitably undermine the right to health for certain categories of people. You might think that I'm referring to people with low education or in need, or those who were born and live in the private areas of our planet. No, actually, before all these social and economic variables comes a negative determinant of health linked, incredibly, to sex. Even today, being born a woman anywhere in the world and with any income means suffering prejudice with respect to the enjoyment of the fundamental right to health. As a matter of fact, Women's health is penalized not only by the traditional position of economic, social, and labor subordination to which women are subject in any society, but also because medical science has evolved by elaborating a false neutral paradigm, which in reality is decidedly masculine, if not chauvinist. Medical science needs a model to refer to, a prototype to investigate in order to study the functioning of the body, pathologies and possible cures, and therefore, despite the more than evident diversities existing between women's and men's bodies, it was preferred to investigate only the male body as a universal paradigm, and without worrying whether this would compromise women's health. By acting this way, the physical differences that characterize men and women have been ignored and, at the same time, gender has also been neglected. Medicine has thus demonstrated a substantially patriarchal chauvinist vocation by choosing as its sole reference model the neutral man, an imaginary human being, male, of Caucasian race, with a height of at least 1.70 meters and by about 17 kilos. The male body has thus been identified with the anatomy itself, and this prototype would apply indifferently to the entire human race, women and men. Medicine's disregard for women's bodies has been defined by the so-called Yentl syndrome, highlighted in 1991 by cardiologist Patricia Healy in Hereditarial, where she points out how difficult it is for women to be correctly diagnosed and treated for cardiovascular disease due to the different symptoms they present. The article had a huge echo and the headline went down in history, but it was not enough to change a well-established trend. Also, it certainly had the merit of raising a problem that did not only concern cardiology, but every field of medicine, and which remains even today. So, every time we refer to the universality of the right to health, we should think that, even today, women are still many steps behind men. The answer to this hateful discrimination that undermines the fundamental right to health for all women exists, and it is sex and gender medicine, an approach that rejects the pseudo-asexual paradigm that of a male containing within himself the anatomical wall. Sex and gender medicine is everyone's medicine, a new way of realizing the right to health from which we can all benefit, but the road to its realization is unfortunately still long. In this discouraging picture, there is one medical field in which women and men have always been considered different and examined and treated with respect for their differences, and that is the field of reproduction and the sexual organs. The woman's body, in fact, has only been the subject of personalized investigation, both from a health scientific as well as from a legal point of view, in the context of sexuality-related issues and, in particular, about the capacity to generate life. Studies on the female body focused for a long time, at least until the 90s, almost only on the reproductive function and sexual organs, giving rise to what is known as the bikini syndrome, in the sense that a specificity of the female organism is recognized only in reference to sexual characters. Studying the female body with respect to sexual organs and motherhood was the way to control women and reproduction, an essential moment for the continuation of the species, incredibly entrusted by nature to women, who therefore had to be controlled and limited as to their capacity for self-determination. That is why women's liberation and empowerment started precisely from the knowledge and reappropriation of the body as a necessary first step for the assertion of independence. In doing so, women have had to fight obtuse mentalities and habits, often finding themselves in conflict with their husbands, fathers, and society in general, in order to step out of the role of mother and mistress of the house and try to assert a new female position within society, politics, the world of work, and the cultural world. Indeed, this path does not appear to have come to an end, even today. The management of motherhood concerns every aspect, from contraception to the possibility of terminating an unwanted pregnancy, to the willingness to embark on a path of assisted procreation, to the choice of the way to deliver, to the possibility of giving birth anonymously and leaving the child in a suitable facility that will then proceed to adoption. All these cases should be left to the conscious and informed choice of the woman, and in no way conditioned by a dark and patriarchal view of medicine and society. As to motherhood, which as seen has been one of the few aspects studied by medical science and also controlled by the legal approach, a paradox is highlighted, and that is the absolute lack of interest in the development and application of gynecological methods aimed at minimizing, if not eliminating, psychological and physical stressor on women giving birth. Genesis teaches that Eve, having eaten the apple of knowledge in the Garden of Eden, is punished by God with the anathema, "I will multiply your sorrows and your pregnancies. With sorrows you will bear children." So women of all times will be condemned to suffer the pain of childbirth, with no right to complain, having to take it for granted. The realization of motherhood through childbirth is a moment still covered by substantial reserve, and in the collective imagination corresponds to a happy and delicate parenthesis experienced by mother and child in complete serenity. Unfortunately, however, this idyllic picture does not always correspond to the reality of fact, and women are very often subjected to real physical and psychological violence at the moment of childbirth, as if the current healthcare systems felt obliged to fulfill the prediction of Genesis. This is the so-called obstetric violence, one of the many ways in which a woman's self-determination about her own body is mortified and thwarted. Obstetric violence, according to the provision of the Venezuelan law of 2007, is defined as the appropriation of a woman's body and reproductive process by healthcare personnel, which is expressed in inhuman treatment, abuse of medicalization and pathologization of natural process, resulting in the loss of autonomy and ability to freely decide on one's own body and sexuality, negatively impacting the quality of life of women. As such, this is true violence, the abuse of position of power that can occur in obstetric gynecological care by healthcare providers, who may impose treatments, practices, or implement behaviors without providing the appropriate information to the woman, but also against the will of birthing woman herself. One might think that these are borderline cases, residual hypotheses of little, if not non-existent incidents. But unfortunately, this is not the case. So much so that in 2014, the World Health Organization published a declaration entitled "The Prevention and Elimination of Disrespect and Abuse During Labor and Delivery in Healthcare Facility," in which it highlights the existence of an unfortunately widespread phenomenon, although almost completely unknown to those who do not deal specifically with these issues. Abusive treatment that can occur during childbirth in healthcare facilities include direct physical abuse, humiliation of the woman, verbal abuse, but also the implementation of coercive or unconsented medical procedure, lack of truly informed consent, refusal to provide adequate pain management, serious violation of privacy, and finally, neglect to childbirth care causing otherwise avoidable complications that endanger the woman's life. Obstetric violence constitutes a true act of oppression, aimed at dispossessing the woman from managing and making decisions about her own body at a time of extreme delicacy and vulnerability. On the other hand, it would be completely unimaginable for a similar behavior to be carried out in any other medical situation. Surgical cuts performed without requesting the consent of the person concerned, refusal to administer anesthetics, invasive and dangerous maneuvers carried out without any informed consent. In short, everything that cannot normally take place in a health care facility is considered permissible at the moment of childbirth, as if the women were little more than a container. Obstetrical violence does not only concern the moment of labor and delivery, but involves the entire gestation, as well as the procedures aimed at artificial insemination and also the postpartum period, a time when women are particularly vulnerable and medical and obstetrical behaviors appear very important. Feeling wrong, inadequate, bad mothers contributes to the exacerbation of depressive states and makes motherhood a real nightmare for thousands of women. Today, fortunately, some countries have decided to legislate on these issues, and in any case, the topic of obstetric violence is slowly emerging from a kind of taboo that served not so much to protect the privacy of mothers as to isolate and discriminate against them. Unfortunately, Europe seems more uncertain than, for example, Latin American countries about the definition of obstetric violence. In our country, an opinion campaign began in 2016, Basta Tacere, that thanks to the testimonies of thousands of women who have narrated the abuse and mistreatment they suffered during childbirth assistance, has led to the creation of the Observatory on Obstetric Violence Italy, with the task of guarding, collecting and disseminating testimonies, monitoring the incidence of practices that constitute this type of violence, and raising awareness of the phenomenon of obstetric violence in the Italian society. In March 2023, the Anche a Me campaign was launched to promote the adoption of a law in defense of women and their rights related to motherhood, not only in the delivery room, but also trying to undo the rhetoric related to motherhood. Also very important is the work of the Mamme a Nudo community that is very active on Instagram and other social media. All these movements help women understand that their stories of obstetric abuse are common to many others and that all violence should be stigmatized and denounced. I think it is very important to highlight the case of obstetric violence. It is indeed a matter of respecting and implementing the right to health of women who have become or want to become mother. A new approach is needed from both health and legislative point of view, an approach based on respect and enhancements of the role of women before, during and after childbirth. With this in mind, therefore, the style exercises operated by obstetricians and gynecologists who stigmatize the use of the term violence and prefer that of obstetric mistreatment because violence implies intentionality on the part of health workers, when instead it may be the result of problems related to the structure in which they operate or to a lack of training, do not appear to be acceptable. In reality, obstetric violence is ultimately one of many ways in which attempts are made to deprive women of control of their own bodies at one of the fundamental moments of their experience as women, making it so that women cannot decide how to give birth, deprive them of their most envied characteristics, the ability to generate new life, a power that men have always sought to direct and control. But it is unthinkable that these behaviors continue to be accepted as normal and inevitable. Women are fully capable of managing their own motherhood well before the moment of birth. They can decide if and when to become mothers and even how to become mothers. Reasoning about the concept of obstetric violence can therefore be very useful in affirming women's self-determination over their own bodies and in reorienting medical protocols where necessary. On the one hand, improving birthing experience for mothers and children, and on the other hand, contributing positively to the performance of hospital staffs, work in a perspective of promoting equality and culture of quality. Obstetric violence is a kind of violence, is not a mistake nor a medical malfunction, is a behavior that perpetuates a patriarchal and masculinist attitude of medicine that must be strongly opposed. Obstetric violence has a relevant place in the definition of women's self-determination on body management and health, because it is time to recognize women's ability to decide for themselves in every situation as fully capable and responsible subjects on a par with men, and especially to be treated with respect and care in the realization of one's health and motherhood. Sex and gender medicine, fighting obstetric violence, self-determination, women's empowerment, combating gender violence and feminicide, cancel gender gap pay are all essential building blocks for realizing the principle of equality, regardless of sex. And they should all be pursued with determination and clarity. That is why it is very important to be here today. Thank you very much. Grazie.
Okay, so I leave the floor to Camilo. You have a very wrap-up presentation about the situation in Argentina and Venezuela, just to say some words about where we have laws and what the laws tells us. So here we go.
Thank you, Professor. Now I will just briefly refer to Argentina and how they have regulated obstetric violence expressly in two laws. They use two laws. First, a little bit of context. During the late 90s and the beginning of the 2000s in Latin America started a movement to be more public the situation of obstetric violence. We talked about obstetric violence because we do not do the differentiation between gynecological and obstetric over there until now. So it was very common in the region, this movement. Women started to speak louder about the problems and their experiences during childbirth, basically. The first country in the world in 2007 to approve a law, the organic law regarding women's rights to life free of violence. It was Venezuela, which was we will refer Sara after. And then Argentina just followed the example. And in other countries, it's very important to say as a context. For example, Mexico started to regulate not at a national level, but they have under states, Mexican states, they have different regulations regarding obstetric violence, specifically under criminal law. They criminalized this type of violence. The development, the common development of all these countries are that even when they don't have the same definition for obstetric violence, they share some common features. The important ones for me are, for example, not only the mistreatments that women received, but the extreme medicalization of the process or the pathologizing the natural processes of women. Okay, Argentina. We have to differentiate between before 2004 and after 2004. Why? Because before 2004, that was the year when they approved the first law regarding the humanized childbirth. The high rates of obstetric violence were pretty similar across all the region. For example, one of the parameters that they used was maternity death. It was very high, 4.8 women in 10,000 died. And so they approved this first law for a humanized childbirth and recognized a group of rights to women, to newborns, and to families in general. It's not something regarding only for women, but the whole spectrum of intervenings. Then in 2009, after or following the example of Venezuela and very inspired by the Belém do Pará Convention, which is the American States Convention for the Elimination of Violence Against Women, they created and elaborated this new law. The one it calls the integral protection of women, the law for integral protection of women, which has or aims to prevent and sanction gender violence in general. It's not only for obstetric violence, but gender violence in general. And the innovation here was that in Article 5, letter F, they recognized expressly a legal concept of obstetric violence. They define it as the one exercised by the health personnel over women's body and reproductive processes, manifest in a dehumanizing treatment, abuses of medicalization, and pathologizing of natural processes. It's very similar to the one created in Venezuela. Well, even what's the problem? Why until today, after decades, the situation in Argentina or in Latin America, it's pretty the same. We still have violence. We still have obstetric violence in specific, that even when they recognize and have a broader set of rights for women, the problem is there is no sanctions. For example, the law for the humanized childbirth only considers in Article 6 sanctions, administrative sanctions for healthcare personnel for qualifying processes afterwards. And most of them only applied or easily applied for the ones who worked on the public services and not in the private ones. And the second law, the one for that expressly recognizes obstetric violence, doesn't consider any sanctions. So they don't have a way to really go for seek responsibility at the end. I think that this was or is the main problem on Argentinian legislation. So I will refer very shortly about the judgment of the Inter-American Court of Human Rights that delivered in November 16, 2022, which condemned the state of Argentina. And it's very linked and related to the situation and the context in that country. The facts were that Cristina Brites was a woman who had 39 weeks of pregnancy, gestation. She went to the public hospital in Buenos Aires and she claimed back pain and she was bleeding. She had a record on the hospital of hypertension. They knew which was her situation and health. And when they performed an ultrasound scan, they informed her that her baby was dead. They don't know why, but the baby was dead. So they had to perform an induced labor without any alternative. They didn't give nothing information. They just said, you have to be under an induced labor. After the proceeding that it took, I think that maybe 3 hours, she was moved to the maternity ward. And because it's a public service over there in Latin America, specifically in South America, the facilities are not great. There wasn't availability of hospital beds, so they moved to a chair. They moved her to a chair where she had to wait. And during this waiting, she died. The problem is that there's not an official cause of death because all the proceedings, the family started a huge movement in Argentina. They asked for autopsies, for administrative sanctions. They went before courts, before the first level of court. They arrived until the Supreme Court. And at the end, because all the reports and the physicians, They have ones that defend itself, of course, and others that were not in the same position with the others. At the end, they didn't have or deliver any report that established a real cause of death. So at the end, the family went to the Inter-American Court of Justice for Inter-American Court of Human Rights, present the case, and after 30 years, they received an answer, basically. The court condemned the state of Argentina and considered it was responsible internationally for this death, and condemned to pay to the children, because she had 2 other children, condemned to pay a compensation. But one of the most important other points of this decision is that regionally and internationally, we have a legal concept of obstetric violence, which is in paragraph 75 of the decision. The court established that is a violation of human rights and is a gender-based form of violence, which encompasses all situations of disrespectful, abusive, neglectful treatment or denial thereof that take place during the pregnancy, childbirth, or postpartum period in private or public health facilities. So for us in Latin America, the decisions and the jurisprudence delivered by the Inter-American Court of Human Rights is very important. It has very huge influence on our courts, national courts. So I think that this decision is a very big deal and milestone in our jurisprudence, because now even national courts will start to apply, and I think consider this decision according to the Inter-American Convention and Belém do Pará Convention. So, thank you.
Brief and effective. Thank you so much, Camila. And now I give the floor to Sarah. Camila is actually an Netherlands student from here, and she's hopefully, finger crossed, PhD candidate next year. So we hope that we will make it. And Sarah, she is PhD candidate here at the University of Milan, State Department of Marilisa D'Amico, and she will tell us about the Venezuelan case. Before giving the floor to her, since unfortunately I have to leave early for personal reasons, unfortunately. I would like to thank all of you, especially, the panelists. With you, I already texted you, I will get back to you in just days, but for all of you who had the time to stay here until the end, and obviously I know that it was pretty intense. But for those of you who are interested, we will have a recording of the presentation, and we will launch the video of the panelist who wasn't able to come, who is Professor Rashida from the University of Bologna. So for those of you who will be interested in the video recording, we will get into it. And I give the floor to Sarah because she needs to talk.
Thank you. I'll be very, very quick. I would like to talk with you about the Obgyn and obstetric violence around the globe, and especially the Venezuelan case. And as we've seen before, the concept of obstetric violence was born in the late 90s in Latin America, thanks mainly to the activism of associations committed to promoting a greater humanization of childbirth. In Venezuela, obstetric violence is strongly connected with the context of perpetration of the acts of violence and the active subject act the acts of violence. In fact, to the normal welfare deficit typical of the delivery rooms, for example, failure to summon the anesthetic or gynecologist by obstetrical staff, or violation of the confidentiality of the woman in labor, are added derisory comments, misogynistic attitudes, insults, and other form of contempt, including explicit references to the sexual activity of the women and her inability to manage childbirth. So I forgot my slides. For a definition of obstetric violence, we need to consider, as we said before, the context of perpetration and the personal professional qualification of the active subjects. First of all, obstetric violence occurs in childbirth care and other therapeutic services related to sexual and reproductive health provided by health facilities, and not by chance. The Actives Association, I've said before, engage in the prevention of abuses in childbirth, promote childbirth at home, which should remove the woman from the abuses of the hospital staff, but which arise other many problems. Second of all, obstetric violence is committed by the operators of the health and social professional facilities. So we can say that part of the obstetrical abuse originates from the pathological distortion of the hierarchical medical-patient relationship, from the degeneration of the old medical paternalism, far from surpassed within certain specialization. So the woman is treated as a patient incapable of self-determination, emotionally unreliable, and deserving of information and involvement in the choices concerning childbirth. In Venezuela, as we said before, Venezuela is the first country that introduced the definition of obstetric violence in 2007. And I quote, obstetric violence is the appropriation of the body and reproductive processes of women by health professionals, which is expressed in a treatment in human, in the abuse and in the pathologization of process natural, resulting in loss of autonomy and ability to freely decide on one's own body and sexuality, impacting negatively on the quality of life of women. In fact, according to Article 51 of the law, are acts of obstetric violence offering inappropriate and ineffective assistance in obstetric emergency, preventing early mother-child union, preventing the presence of a companion, and in general alter the natural process or the acceleration induction of the childbirth. But as the data shows, in Venezuela, most of women suffer from a form of obstetric violence, meaning the lack of informed consent and information. So, in conclusion, there is no doubt that the certain manifestation of obstetric violence originates in effects from the recrudescence of paternalism toward patients, but the gender element, as we've seen before, is very central and important because, as for gender violence in general, also obstetric violence finds its roots in the lack of consideration of women's self-determination and their reliability and credibility. So obstetric violence makes it possible to reverse the point of view, meaning that if women have always been considered in the role of mother, it seems that with obstetric violence, they are again limited in their rights and freedom, also in the field of motherhood in which they've always been considered. So obstetric violence is yet another proof that women are limited in their freedom. First of all, the right to informative consent, and as Venezuela teaches us, law cannot be the only solution. Thank you.
As you clarify, obsessed with consent. So guess what her thesis is about? I'm kidding. So thanks so much for everyone. I made it to be here at the very end. I couldn't leave. So thanks again. And I hope to stay in touch with all of you who are interested and with our guests. Talk to you tomorrow, okay? Thanks so much also for, everyone, okay? Bye, also from home. Bye, thank you.